the Honorable David Owen for that. Make sure all your cell phones are turned off. Got your hand for a moment of silence. Thanks, you may be seated.
Yeah. Predestined, right? You already know what you're gonna say. We're getting transported first. Commonwealth versus Amy Burchett. Okay. And then Sydney Foster. Commonwealth versus Amy Burchett, 22 CR 0051. Are you Amy Burchett?
Yes, Your Honor.
Born in 1990.
Yes, Your Honor.
Last four digits, social security number 5052.
Yes, Your Honor.
You're on a probation revocation. What does the Commonwealth have to say?
Your Honor, Ms.
Just
Burchett
step to your left here, ma'am, a little bit. Mr. Stockton, you get behind the podium, sir.
Ms. Burchett had a 5-year sentence on receiving stolen property. She was probated. She was ultimately placed into drug court. She became pregnant, had 2 positive drug tests for meth. She was placed in a rehab for pregnant women, had her child successfully. Ultimately, she was released from that rehab because she wouldn't follow her policy guidelines, which was co-sleeping with the child. And there's probably at least 10 references in the notes where she was warned not to do that. And she continued to do that. So she was terminated from the rehab and ultimately terminated from drug court.
She was accused of sleeping with the child.
Yes, their policy at the house was that, as you know, co-sleeping is dangerous when you're sleeping with a premature baby. And she was sleeping with that child, and I've got the records here, and she was warned at least probably 10 times not to do it, and ultimately they had to discharge her because she wouldn't follow the guidelines.
And Judge, I think the big point is there was no cabinet involvement, there were no charges brought against Ms. Burchett. She was sleeping with her child because the child was crying.
Are you testifying here?
Judge, actually, we have a,
We've got the lady supposed to be lined up on Zoom.
She won't stipulate? Let me tell you what, we've got too many cases where children are dying that are premature and people are involved and they sleep with them or their boyfriend sleeps with them and they roll over and the baby put down on their face and everything. I don't know. I'm not sympathetic to why she was sleeping with a premature baby.
well, Judge.
But I don't know that she
Judge,
is,
if
but
it's
I'll have to have some testimony on the thing, because I'm not accepting what you say or what I think. You know what I mean?
I understand. Judge.
Okay, you want to pull, if she doesn't want to stipulate, well,
She's supposed to be on Zoom here. We can get that filed up. Miranda Lowry is her name.
okay, well, somebody needs to try to trace her and
I'm here.
we'll come back to your case.
And
Okay.
Judge, just a point of order, this is the second time maybe she's going to be available. We were ready for a hearing last fall.
She's on here right now. Lost that argument. Okay, you gonna pull her up? Okay, what's this witness's name?
Miranda Lowry.
Miranda Lowry, would you raise your right hand, please? You swear the testimony you're about to give is the truth, the whole truth, nothing but the truth.
Yes, Your Honor.
Okay, state your full name, where you work, and what your position is.
Miranda Cheyenne Lowry, and I work at Independence House in Corbin, Kentucky. I'm the assistant director of the program.
We got some kind of audio problem.
Feedback.
It doesn't help you to be up here.
Yeah.
It's not coming from up here.
Okay. Ms. Lowry, what's your title or your qualifications for your position?
My qualifications are licensed professional counselor associate and licensed clinical alcoholic drug counselor.
Okay, I'm having trouble understanding you, ma'am. Is there another speaker system on in your office there?
Can you hear me any better?
Okay, try to say something now.
Can you hear me now?
That's better.
Now, does your facility, does it, house, women that are pregnant or have small children?
Yes,
And you have certain guidelines that have to be followed when, pregnant women or young women with children are housed at your facility?
yes.
And could you give us some examples of those in order to protect the woman, the mother and the child?
To protect the mother and the child, they are not allowed to co-sleep with the children. They have to have eyes on adult supervision at all times of children. Mom is required to tend to children's needs, and request staff assistance when needed. Um,
Okay. Are you familiar with the case involving Amy Burchett?
yes, sir.
And can you tell us if you reviewed her records?
I'm sorry, what?
If you reviewed her records prior to testifying this morning?
Yes,
Okay. And did she come to your facility while she was pregnant or after she had the
she
child?
came while she was pregnant.
Okay. And after the child was born, and did the child stay with her at the facility?
Yes,
And did she have any problems, or did she have any problems complying with the facility's rules?
yes, she did. I had multiple staff reports and I personally witnessed, 2 incidents myself.
Instances of what, I mean?
Her co-sleeping with baby,
Judge,
both times.
At this time I would object, I would ask that the witness be confined to what she testified as to those 2 occurrences. To go into the other alleged occurrences would be hearsay unless those witnesses are available.
It's a business record hearsay exception, and I can lay the foundation if necessary.
Hey, let's take the time to do that if you want to. Yeah, go ahead.
Ms. Lowry, are records kept at the facility as regards the patients and the children?
Yes,
Are those records made at or near the time the events occurred?
yes,
Is it the normal course of business for the facility to make such records?
yes.
Your Honor, I'd ask that the records have been attached to the Commonwealth's motion be entered into evidence in this case.
Without objections ordered.
Okay. Now, Ms. Lowry, you said you witnessed 2 incidents of her co-sleeping with the child. Is that correct?
Yes.
What would your staff do when she would be co-sleeping with the child?
Staff would intervene, go to her room, remind her that she was not allowed to sleep with the baby, remind her once she had done that multiple times that she was at a possibility of being terminated from the program. I reminded her myself that she was not allowed to co-sleep with the baby and that she would be terminated from the program if it continued.
Okay. Do you have the records in front of you today?
I do.
Okay. Okay. I'd ask you to go to the entry on 12/9/23.
Is that a staff note or a progress note?
That's a staff note by Summer Martin.
Okay, I'm there.
Okay. And does that staff note reflect that Amy was caught co-sleeping with her infant on 12/9 and that she was, tried to argue that she was not asleep?
Object, Your Honor, at this point, Mr. Bottom's testifying.
Ask her what it says then.
That's what I'm just quoting for the record that's been introduced into evidence.
That's exactly right. But we're gonna go give leeway to the defense counsel on this thing. Let her talk.
Yeah, what does that record say about the co-sleeping Miss Burchett was doing with the infant?
The record states Amy was caught co-sleeping with her infant, stated she was just trying to feed her. She was told that under no circumstances are you allowed to lay down with an infant due to accidentally falling asleep and other safety issues that may arise. Tried to argue that she was not asleep.
And was that signed by Summer Martin on 12/9/23?
It was electronically signed by Summer Martin.
Okay. Then can you go to 12/10/23?
Can you tell me who posted the note?
That's a staff note, 2 staff notes by Summer Martin on 12/10/23.
Yes, sir. Okay, I'm there.
Okay, and what do those notes say?
When staff was performing bed checks, Amy was found laying down with her infant asleep. Client was been told multiple times about the dangers of bed sharing.
And was that electronically signed?
By Summer Martin on 12/10/23 at 9:18 a.m.
Okay, and was there another note from that same date?
Yes, sir.
And what did it say and what time was it?
Client was found asleep with the baby on her chest. They were told to place the baby in their bassinet. Signed by Summer Martin on 12/10/23 at 12:32 a.m.
Okay. Could you go to the next staff note on 12/15/23?
Is that one by Summer Martin as well?
Yes, ma'am.
Amy was found laying down with her infant twice during the night. The first time she was told by staff to lay the baby down in the bassinet 3 separate times, and eventually she complied. The second time she was found laying down with the baby. She appeared to be asleep, head laying off to the side, snoring. And once staff got her to respond, she said she was trying to get the baby to sleep. The infant was asleep on Amy's chest. Amy then proceeded to get argumentative with staff, saying she was not asleep and said, "Why are you giving me a hard time?" Staff told her to lay the baby down in the bassinet and continued with bed checks.
And that was on 12/15/23?
At 4:03 a.m.
And that was signed by Miss Martin?
Yes.
Okay. Could you go to the staff note for 12/18/23?
By Sherry Davis.
Yes, ma'am.
Staff was doing bed checks. Amy was co-sleeping with baby again. Staff wake her up and told her she could not be sleeping with the baby on her chest. Staff has talked with Amy about this matter. Staff has consequenced Amy for this multiple times. Staff has even had a chair put in Amy's room to prevent this. Amy continues to co-sleep, knowing the dangers of co-sleeping. Electronically signed by Sherry Davis on 12/18 at 12:13 a.m.
Was the chair placed in there so she could sit up in the chair with the baby?
Yes.
Okay. Now, there's another staff note from 12/19/23. It looks like by Jessica Mitchell. What does that say?
While doing bedroom checks, staff found Amy with infant in the bed with her on 3 separate occasions from midnight to 5 a.m. Repeatedly, staff warned Amy and told her she needed to get up with the infant and she could not be sleeping with her. It's too dangerous, only to find Amy having her infant back in the bed with her. Amy told staff several times she would not do it again. Staff told Amy at 5 a.m. she would have another consequence for disregarding staff and continuing to break the rules.
I want to skip over to 12/21 of 23. If you can find that staff note, please.
12/23.
12/20. It's actually, the date is 12/20/23, but it's signed on 12/21 by Sherry Davis.
You said the note was signed on 12/21.
Yes.
Okay. Staff was doing bed checks around 11:20 p.m. Amy had the baby in the bed. Staff told Amy, "You cannot have the baby in your bed." Amy said, "I will put her in her bed." Staff did bed checks again around 11:40. Amy was asleep with the baby on her chest. Staff woke Amy up and again told Amy to put the baby in the baby's bed. Staff has worked with Amy to try and stop this co-sleeping problem. Amy just keeps sleeping with the baby on her chest. Staff has talked with Amy about the dangers of co-sleeping. And that was
Okay.
electronically signed by Sherry Davis on 12/21 at 11:06 p.m.
I know there's a lot more of these, but I want to skip over to 12/27/23, signed by Vanessa Vaughn.
Is that a progress note?
It says staff note on it. Looks like by Jessica Sturdivant. Approver was Vanessa Vaughn.
Okay, you said, and that's on 12/29.
12/27 is the date of it.
Okay, I'm sorry. Staff was sitting in treatment room watching a baby while the mother smoked. Amy's baby was in a bouncer, and she kicked the bouncer with baby in it towards the table, not once, but 3 times, and I told her to stop. She laughed and said, "I'm not hurting her." I told her I didn't care, that it was dangerous, and we don't do that. She eventually made it to the table with baby and bouncer behind her in the floor.
Okay, and I'm gonna skip over to the end. Was Miss Burett ultimately terminated from treatment at the rehab?
Yes.
And why did that occur?
On the day of Amy's termination, Amy had a camera placed in her room so that staff could monitor baby more closely. Amy agreed to having the camera placed in her room, and while monitoring the camera, another staff member reported to me that Amy had picked the baby up by the front of its sleeper and had the appearance of a rag doll. Again, this was reported by another staff member to me. At that point,
She was improperly lifting the baby.
yes, she was not supporting the baby's head. And you can see that documented in one of Kristen's notes.
Yeah.
The staff member was Kristen Lunsford. So me and Kristen went to Amy's room, told her, "You cannot pick the baby up like that." She said, "Okay, okay." We left the room. We contacted our program director, Georgia Douglas. I discussed with Georgia incident that had occurred yet again. And me and Georgia decided to terminate Amy from the program.
I have no further questions, Your Honor.
You may,
Thank you, Judge. Ma'am, can you hear me?
If you get over here to the microphone.
Ma'am, can you hear me okay?
Yes.
So I want to talk about some of those notes, particularly progress notes that you and Mr. Stockton didn't talk about. I want you to go to a progress note dated 12/19. Are you there?
Yes, I'm here. I'm looking. Who submitted the note?
So you see that progress note?
Who submitted it? Who is the author of the note?
Want to say that was the practitioner. Give me just a second. Let's see, this is signed by Georgia Renee Douglas.
Can I ask for the date of that note again?
Certainly, December 19th, 2023.
I'll let you read it. There's no objection.
No, it's in the record.
It's in the record. You go ahead and read it rather than whatever you want to and ask her to verify it. Okay.
Okay. So ma'am, if you're looking at this document, Amy's receiving some behavioral health services at this time, correct?
Yes.
She's talking to a clinician about some of her problems.
Yes.
She talks about being tired in that meeting, doesn't she?
Per the documentation of that note, Amy stated, "I'm tired. I'm getting baby blues, and I don't mean to."
I'm glad you mentioned baby blues. That was going to be my next question. When a client or a patient there talks about the baby blues, how do you interpret that?
That they may need further assessment if I had been the one that she had been reporting that to, or that they may need referred to another therapist for assessment, depending on who that's being reported to.
And again, ma'am, you have all of Amy's records there in front of you, right?
Yes.
So you would know that she actually saw another clinician by the name of Tim Couch, right?
Yes.
And you would also be aware, being the director, that is it Dr.
I'm not the director.
Well, in your role there, having been custodian, having all those records there in front of you, like you testified earlier, you would know that Dr. Couch diagnosed Amy with postpartum depression, correct?
I can look at the record that was documented by Tim Couch, and Tim Couch is not a doctor.
So what you're telling the court right now under oath is you're not aware of that diagnosis.
I said I can look at that documentation.
Do you have documents? Is it in the record?
It's not in these records.
Well, I'm just asking you, is it the record? There's no reason to have her, the reason I'm asking, there's no reason to sit here and have her look through these records if you know they're not in the record.
They're not in the records.
Okay, so move on.
Go ahead. Ma'am, the staff members that you referenced, are they trained and equipped to deal with patients who have been diagnosed with postpartum depression?
Our staff that I referenced are temporary certified alcohol and drug counselors, as well as temporary registered alcohol and drug peer support specialists. And Summer Martin is a residential tech without licensure from the state.
So I'm guessing that'd be a no to my question.
No.
So if we're looking at all these notes, and I jotted down times as you were going through with Mr. Stockton, that first note on December 9th, and you testified to this, that note was at 1:38 a.m., right?
Can I have a moment to look back at that record?
Absolutely.
You said December 9th?
Yes, ma'am. And actually, while you're looking through those records, because I was gonna ask you about all those dates. if
Wait,
you wanna-
wait,
Yeah, I
wait,
wanna
just a
take one question
second.
at a time.
Wait just a second. You can't ask somebody to look through records and then ask them another question while she's looking through them. I mean, multitasking is one thing, but that's ridiculous. So if you want to let her look through the records and find something, we'll wait. We've got all day here.
Okay, I've located that note. And can you repeat your question?
That time entry, what is it?
The note was entered on 12/9/23 at 1:40 a.m.
Now I want you to go to that December 10th note that you testified about earlier.
Judge, I'm gonna object. If he's just asking what the records say, that's one thing.
Yeah.
If he's got a question about the
What's
records, that's
what's
another
the
matter.
point here? Get to the point. Ask her. a
Well, Judge,
question.
my initial proffer question was going to be for her to review the records, and I was going to ask if
There
all.
are 50 pages of records here, okay? What is the question?
Judge,
What
I'm gonna
question?
go the timestamp on each entry. She actually
What's the
testified.
relevance of that?
Well, Judge, if we're talking about an individual falling asleep, I think it is relevant to have on the record what time the alleged individual fell asleep. 1:38 a.m., 12:38 a.m.,
Well, it doesn't matter
4:02.
what time she fell asleep, if she's sleeping with a baby, if she's not supposed to. That's the issue. I'm not saying the lady was not sleepy, or she didn't have postpartum, or I don't know what she has. The issue is, these reports say that she was caught sleeping with the baby, and she wasn't supposed to. So I think Commonwealth will stipulate that the timestamps are what they are.
Yes.
Okay. Now, ma'am, I would like for you to go to, again, a note that Mr. Stockton omitted on 12/24, December 24.
What was
It
the
is
date of
it's an
service?
individual progress note, type of service, info note. Are you there, ma'am?
Yes, I'm here. I'm looking for that note.
And particularly, I want to direct you to what looks like,
Can I ask who submitted the note you're referencing?
this one looks like it was electronically signed by Miranda Yvonne Hamilton on 12/26.
Okay.
So my first question is, who would Miranda Hamilton be?
I'm sorry, I'm still looking at that note, or looking for that note. Is it a transport note?
Says info note.
Okay. I'm not sure I'm at the correct note that you're referencing. Miranda Hamilton is one of our staff at Independence House. At that time, I'm not sure what her credentials were at that time. Her credentials recently changed. I'm not sure if she was counselor at that time or not.
And then that next note on 12/27. So the next page. And it looks like that is signed again by Georgia Douglas.
Was there somebody else who signed that note?
That's whose name's at the bottom of the paragraph.
Was there a different author of the note? Okay, I found the note you're referencing.
And you're there at that note, and I'll ask you, in that note, is Amy talking about a medical condition that this baby has?
I did not witness it, but I can happily read this note to you.
Sure.
Amy came to director stating the baby had a severe diaper rash and needed to go to the doctor. Had medicine at pharmacy for rash, but was told by staff she needed a paper before the baby could use it. Director shared if baby had a prescription, she does not need any other information. The prescription was enough verification needed for baby to have the medication. Amy proceeded to show director the rash, which was very red and irritated all through her private areas and lower belly and down her legs. Director asked Amy why she did not tell staff medication was at pharmacy before now. Amy shared she was informed by staff she needed a paper, but would not tell director which staff other than evening shift. Director suggested.
Ma'am, you can stop there just for. So reading that note, Amy's talking about this baby having a medical condition on 12/24, right? A diaper rash. Yes, you read that?
On this date of service was on 12/27.
And this diaper rash, the clinician actually identified it, talked about it being red, right?
Yes. Per the report.
Needing medicine, right?
Per the report, yes.
Fussing on Amy about not getting medicine before 12/27.
I'm gonna object to this line. of
What is the
questioning.
relevance to this?
Well,
Well, Judge, we've got
What
it.
is the
two
relevance?
things. It's irrelevant. It's not irrelevant, but he cut her off before he read the rest of the
I
letter.
wanna know what the relevance is of a diaper rash.
Again, Judge, if we've got a mother holding a child, and if I may proffer, Ms. Birch is going to testify as to why she was holding the
Why
baby.
she was asleep, why she was sleeping with the baby.
Why she was holding the baby.
Why she was sleeping with the baby on these multiple occasions. She's gonna testify, we'll allow her to do that. Okay,
At this point, Judge, at this point, what I'm establishing is
It's
that,
got severe diaper rash, and it should have been taken to the doctor earlier, and the baby was in bad shape, and they didn't provide medical services, or she didn't ask for them. That's what you've proven at this point. Go ahead, move on.
ma'am, I just have a few more questions for you. You are a mandatory state reporter, correct?
Yes,
Meaning you see abuse, you are required by law to report it to proper authorities, right?
yes, sir.
Are your staff under that same oath and responsibility?
Yes, sir.
Mandatory reporters.
Yes.
At what point was the cabinet notified of problems with Ms. Burchett and this child?
It is documented in the record by Georgia Douglas. Would you like me to pull up that note and read it to you?
Please. And ma'am, while you're pulling that note up, Miss.
No, why she's pulling the note up, you let her pull the note up.
I found the note. The date of service was 12/28/2023. It is an info note under individual progress note. Director Georgia Douglas contacted Whitley County Social Services and spoke to Jason Snell regarding of co-sleeping, propping bottles, and getting baby out of the bed by one arm rather than picking the baby up. Jason informed none of these are reportable offenses to open a case for investigation. That once a case is open for other reasons, they recommended that parents do not prop bottles or co-sleep. Also, if baby was not injured or the intent was not to injure the infant, pulling of the arm was also not a reason to intervene. However, these are not reasons to open a case. Signed by Georgia Douglas, IH Director.
So that last thing was, there was a decision made not to open a case?
Per social services,
And,
per the report in the record.
and again, looking at those instances, at any point did you or any of your staff report any of these sleeping with the child to law enforcement?
No.
Thank you, ma'am. That's all I have.
No redirect.
You may be excused. Thank you for your cooperation. Okay, Mr. Stockton, you have anybody else?
I have no further proof, Your Honor.
You have anybody you'd like to call?
I do judge I guess the one caveat is, if the Commonwealth is known through proof, I would object at this point is we've had no testimony from anyone from special court outlining the termination. All we have is a piece of paper. Mr. Stockton proffered, I know he attends specialty court, so I would think we need someone from special court as
Okay,
well.
let's take a recess here and we'll get somebody from specialty court to come up here and testify.
I'll have to get Mr. Grimes.
Yeah, we'll do that, so we'll go ahead. What we're gonna do is we'll go ahead with these transported prisoners here. And she can go back there. We'll take a recess this one. Sydney Foster. Sydney Foster.
I think, Judge, I don't think he was transported. It was just,
Why, what's he transported? There's a transport order. What happened to the transport order?
Sheriff, I mean, most people, just like we have someone for that.
and Judge, I had the sheriff going in a lot of different directions this morning.
Well, you're not supposed to have the sheriffs going anywhere.
Well, via the.
Okay, no, that's exactly the point. You did have the sheriffs go in place. You told the sheriffs not to transport some of these people that have transport orders. When that happens, then we don't have a Zoom hookup with them and they're not able to be here. Now, what's the story on Sydney Foster? What kind of motion were they supposed to have? It's a plea. Well, why did you tell them not to bring Sydney Foster over?
I did not.
Okay.
That's plea.
What about Dennis Kempton? Why wasn't he transported?
And Judge, we had an agreement with Commonwealth, that's that case, that was.
Okay, let's go down through here with these things. Give me a pen.
Your Honor, do you all need Sidney Foster? I'll get him out of the cell for you.
Yeah. What about, get Sydney Foster up on the line, please. What about Dennis Kempton?
We don't have
Doctor,
Mr.
what
Kempton.
about Dennis Kempton?
My understanding from Mr. Pennington was he was gonna be passed. We had an agreement. Then he said he's coming up for parole, so he didn't want to enter a plea.
Okay, we're passing over that. What about Janet Owenby?
Well, I guess we need a trial date because I've been jacked around twice now. She's supposed to enter the plea. She's not going to, so instead of trial, she'll be tried.
Okay, is Janet Owenby here?
Yeah.
She's been transported, okay. Okay, let's get Sydney Foster up and then we can, allow.
We brought them stiff to the
Cindy Foster's transported was a flower. Or something on the 12th day of fifteen.
They're gonna bring Sydney Foster up. While we're waiting for, Sydney Foster, let's get Janet Owenby out here. And that way y'all can head back, is that right? Take them back, cause we're only two to go.
Your Honor, here's Mr. Sidney Foster.
Okay, we'll be. Sydney, if you wait just a second, we'll be right with you, okay?
Okay.
Janet Owenby. Commonwealth versus Janet Owenby. 23 CR 0035. Are you Janet Owenby?
Yes, sir.
You born in 1962? The last four digits of your social security number is 0936.
Yes, Your Honor.
Mr. Stockton, what do you have?
We have.
If you come up here, if y'all move to the left and Mr. Stockton move to the left.
We either have a pre-trial diversion plea or a motion to set for trial. I don't know which we have.
Judge, we have a pretrial diversion agreement. Their pretrial diversion agreement.
Ma'am, a motion has been tendered that says you wish to enter a plea today. Is that correct? Can you hear me?
Yes, Your Honor.
Okay, you wish to enter a plea today? Okay, are you currently under the influence of drugs or alcohol?
No,
Is this plea freely and voluntarily given?
that's,
Okay, you were born in 1962, is that correct? Last four digits, social security number 0936.
yes,
Is your judgment impaired in any way today? You know what's going on?
yes,
Okay. Have you discussed this matter with your attorney and are you satisfied with his advice?
yes,
Have you reviewed the evidence the Commonwealth has against you and you believe you're fully informed about your case?
yes,
You understand that you do not have to enter a guilty plea today. You have certain rights under Kentucky and the United States Constitution. Before I can accept the plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. You have a right to speedy trial budget. You need,
We're ready.
oh, well, you're going through papers with it. You're a much better multitasker than I am. When I'm talking to somebody, I like you to listen to me and not to be distracted. It's very important that she hears this and goes through it, okay? You have a right to be represented by counsel at your jury trial. You have a right to confront and cross-examine all witnesses called to testify against you. You have the right to produce evidence, right to call witnesses in your favor, right to appeal this matter to higher court if you lose, right to private Commonwealth prove beyond a reasonable doubt that you're guilty of charges against you. You understand that by entering a guilty plea, you give up all those rights. You understand that, ma'am?
that's,
Okay. I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I do not have to accept the recommendation. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you'll have the right to withdraw your plea. Have you previously been a pretrial verdict in the last 5 years, ma'am?
no,
Okay. Do you have any felonies in the last 10 years?
no, no,
Do you understand that if you complete the diversion, the charges will be dismissed pre-trial diverted, and you can have your record expunged as if this never happened? You understand that?
yes, sir.
If you violate the terms of pre-trial diversion and you come back here and I revoke the pre-trial diversion, then I'll have you scheduled for a pre-sentence investigation report. You'll be a convicted felon. And that can be used against you in the future. You understand that? Ms. Gordon Anderson, will you give the recommendation that the council?
Yes, Your Honor. Upon a plea of guilty to wanton endangerment first degree, the defendant shall receive a sentence of 5 years. Upon a plea of guilty to assault third degree, the defendant shall receive a sentence of 5 years. The 2 5-year sentences shall run concurrently for a total of 5 years. Serve 314 days in jail with the balance pretrial diverted for 5 years supervised. As of the entry of this plea, the defendant has served 314 days in jail. Thus, she shall receive credit for time served and be released from incarceration. Defendant shall be referred to ADONTA and follow any and all recommendations. The defendant shall also obtain a mental health assessment from ADONTA and follow any and all recommendations of the doctor. The defendant agrees to have any and all evidence in the above style case disposed of in a manner that's in conformity with the laws of the Commonwealth and the holding agency.
Give me a little detail about this case.
This is a case where Miss Owen was having mental issues and Chief of Police Mark Bell went to her apartment and she hit him with a skillet. Mark's known Miss Owen for many years and he didn't want to put her in prison. He'd
I remember it.
rather do this.
Are you pleading guilty of your own free will, ma'am?
Yes,
And you acknowledge you committed the acts that you charged with?
well, I didn't hit him with the pants.
Yeah, that's what you charged with. Is that your signature on the motion? No, that's your signature?
Judge, you'll have to execute a couple more documents, my apologies. And Judge, the one thing we would ask while Ms. Owenby's executing these documents is, well, she's got some family that may be coming up to get her, but at the same time, social services in Wayne County is working on a place for her. I know it's typical for her to be released the day of entering a diversion agreement.
She signed the document.
She is now, Judge.
Okay, I'll accept the pretrial diversion. Enter the order, she needs to meet with the probation parole officer. Now, what were you saying about, we do not, this is not an adult daycare center over there in Russell County. She's entered this pretrial diversion. I cannot send her back over there. Isn't that right?
She's in Wayne County Jail.
Wayne County, wherever it is.
I think they'll have to take her back up there to release her, won't they?
I don't know. Let's take her back. When can her family be up there to pick her up?
So I have no idea. I have no idea when services could have her in a place. That was my reluctance on even entering a plea today, but it was a plea or set trial, but the version puts her homeless.
Now, I take issue with that stuff.
Okay, what do you,
Her actions and her family make her homeless, not the Commonwealth of Kentucky and not you.
But Judge, I will know there was an order that she was not criminally responsible for actions, so I would take issue with Mr. Stockton's statement.
We're doing our job. So I've got Mr. Cross available for phone. He's in Somerset if you want to leave that here.
got who?
Mr. Cross, the drug court director. We want to conclude that here and I've got him by phone. He's in Somerset.
Well, they can take her back to jail over there. And we'll do a release order. I might not get to the release order until in the morning. Fixing a stack of papers. So you might call social services or whatever and tell her that she'll be over there and she'll have to be released tomorrow. Okay, thank you. Okay, let's go back. Let's do Sydney Foster right now. Sydney, are you Sydney Foster?
Yes, sir.
Let's turn that microphone on there for Sydney. Sydney, you say something, see if I can hear you.
Yes, sir.
Or you have to speak up a little. You're here on 21 CR 00100, pretrial conference for Sydney Foster. What does the Commonwealth have to say?
We have a felony plea.
Mr. Foster, were you born in 1972?
Yes, sir.
I don't have any volume on it. Yeah, I heard it too, but it's not enough. You have to speak up, Mr. Foster, okay? Were you
Okay.
born in 1972?
Yes, sir.
Okay. His social security number, last four digits, 8738.
Yes, sir.
Okay, I understand that you wish to enter a plea today, is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes.
Are you the same person previously identified by year of birth and social security number?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Are you satisfied with the advice of your attorney when you discuss this matter with him?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you, and are you satisfied that you're fully informed about your case?
Yes, sir.
You understand that you do not have to plead guilty today. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything, a right to speak trial by jury, a right to be represented by counsel at your jury trial, a right to confront and cross-examine all witnesses called to testify against you, a right to produce evidence, a right to call witnesses in your favor, a right to appeal this matter to a higher court if you lose, a right to require the Commonwealth to prove unreasonable doubt that you're guilty charged against you. Understand by entering a guilty plea today, you give up those rights. Do you understand that? Now,
Yes,
I
sir,
may
I
consider the Commonwealth's recommendation, but I may apply to range of sense by the law. I don't have to accept the recommendation prior to accept the recommendation. I will wait a pre-sentence investigation report done by probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. What is the Commonwealth's recommendation, Mr. Court Manager?
Yes, Your Honor. Upon a plea of guilty to possession of a controlled substance, first degree, the defendant shall receive a sentence of 3 years to run concurrently with Clinton Circuit Court case number 23 CR 22. The Commonwealth will oppose probation. Then it agrees to have any and all drug paraphernalia and contraband disposed of in accordance with the laws of the Commonwealth of Kentucky.
Is that what you agreed to, sir?
Yes, sir.
Are you pleading guilty because you did commit the acts charged in the indictment?
Yes, sir.
You understand that, because of this plea, if you have any felony convictions in the future, the punishment could be enhanced under persistent felony offender law. You understand that?
Yes, sir.
The constitutional rights still your desire to allow me to fix the punishment.
Yes, sir.
Okay, is that your signature?
And Judge, in the event of the realm of everything that could possibly happen, I walked out, I went over the paperwork with Mr. Foster on Saturday. I do not have any signed paperwork in my bag. I can tender that, but Judge, I don't have it with me. And I don't know, Mr. Foster will not be. He has pled. I know this is one where we were gonna waive PSI, but I understand you need a signature.
Let's get him to send. If we'll send a copy of the document over there for this gentleman to sign. That'll be the only thing left to do in this. I accept the agreement and order a PSI, and I'll schedule a sentencing. But I will, send a copy of y'all have a copy of the plea agreement?
Yes.
Okay, we'll send it over to the jail over there. In jail, if you'll be ready for it, and let him, what do you want to say?
I was gonna say, he just had a PSI. He was sentenced 4 days ago. So it would be.
So you've been incarcerated since then?
Correct, Your Honor.
Yes.
Is Commonwealth all right with that?
Yes, Your Honor.
Okay, so when he gets the signature back, the jail, when we go through the jail docket, we'll let him come back on and acknowledge that signature.
Thank you, Judge.
Okay, let's bring Amy Burchett back out here. And Russell County will be ready with the rest of your Zoom docket in a few minutes, okay?
All right, Your Honor.
Is North Point on there? North Point Training Center. Okay, let's go ahead. Mr. Stockton will call your witness.
Call Mr. Cross, Barry Cross.
Mr. Cross, are you there with us?
Yes, sir, I'm here.
Okay, will you raise your right hand?
Yes, sir, I am.
You swear the testimony you're about to give us the truth, whole truth, and nothing but the truth.
I do, Your Honor.
You may proceed, Mr. Stockton.
Mr. Cross, what's your occupation?
I'm the program coordinator for Clinton Cumming Monroe for the past 24 years.
For the specialty court?
Yes, sir.
And are you familiar with the Commonwealth versus, are you familiar with Amy Burchett being one of your clients?
Yes, Amy Burke is in my program.
Okay, and that was in Clinton County?
Correct, he was a Clinton County client.
Okay, and you recall that at one point in time during the program, she was pregnant?
Repeat that, sir, I'm sorry, I'm trying to drive.
You recall that during one time in the program, while she was still in the program, she became pregnant?
Yes, that is correct.
Did she fail any drug tests while she was pregnant?
Yes, she did. She actually failed two. I think it's listed on the violation there. It's not, I'm not in front of me because I'm driving.
Okay, your violation report, the termination says she was positive for meth on 6/26/23 and 7/8/23. Is that correct?
That is correct. And
Okay.
she was pregnant during one of them tests. Probably the later test, the later date would be the correct one.
What action did the specialty court take after she was pregnant for methamphetamine twice while she was pregnant?
Well, we decided as a team to send her to rehab for 90 days for protection of herself and the unborn baby. And then she was not unable to complete rehab and then came back. And then the judge and team decided to terminate her.
Okay. And basically was the termination based on the drug test and the fact that she wasn't able to complete the rehab and
That is
independence?
correct. It was initially started for drug testing and then on the end result is not complying with the rehab.
Okay, I have
Terminated.
no more questions, Mr. Cross.
Mr. Cross, can you hear me okay?
Yes, sir. I'm sorry. I apologize. I'm doing the best I can to hear you.
No, that's fine. Just let me know if you can't hear me. I just have a few questions for you.
Okay,
So-
go ahead, Jonathan.
So once Amy was discharged from rehab, that was what led to her getting expelled from specialty court, correct?
Yeah, when she was discharged from rehab, she was placed before the court, and the team decided to terminate her at that time.
And you testified that she was sent to rehab for 90 days?
For
Are you aware of how long she was there?
She's there longer. She ended up staying longer due to the baby.
So she actually stayed longer than the 90 days.
Yes, we recommend 90 days first, but with the baby being born, the rehab did it be best to stay longer, so we complied with it.
And for all intents and purposes, Amy's problem wasn't drugs in that 90 days or the whole time she was there.
No, she just had she had some issues, and minor issues, and then the rehab decided to discharge her.
Minor issues and the rehab decided to discharge her.
Well, it was more just minor. It's like it was creating behavior issues. It just kept piling up. It's over.
That's about-
Wayne County. And finally, Mr. Cross, typically when an individual is terminated from specialty court, in your experience, has that led to revocation of their probation?
Objection. That's no way.
That is not my position. I'm not the Commonwealth or the judge who recommends it.
Objection sustained.
That's all I have, Judge.
No more questions, Your Honor.
Okay. Do you have any witnesses? Ms. Cross, be excused.
Yes, Your Honor.
Mr. Cross, you may be excused. Thank you. You have any witnesses?
Judge, Ms. Berger.
Okay, raise your right hand. You swear your other right hand. You swear the testimony about to give us the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
Speak up.
Want to talk louder, ain't it?
Okay.
It's voice activated. You've been here and heard all this, right?
Yeah.
I want to start with rehab in and of itself. Did that work for you? Did
Yes, it worked for me.
you get off drugs?
Yeah. Been almost 10 months clean.
And we just heard Mr. Cross talk about the 90 days. How long exactly were you at that rehab?
I was there for 6 months.
They wanted you there 90 days and you stayed double.
Yeah.
Let's talk about what's your child's name?
Elizabeth,
How old is she now?
she's 3 months.
How old was she? Let's go back to December. How old would she been back then?
She would have been,
Little?
yeah, she was just born.
Heard a lot about you dozing off and falling asleep. What were you doing at those hours in the morning with your daughter?
She wasn't sleeping good and she's crying a lot, and plus she got the COVID while I was up there,
She got the what?
COVID.
Did you also get COVID?
And she wasn't sleeping good. Every time I lay her down, she'd cry. And the only way she would be comfortable was on my chest. The only way I could get her to sleep and where I could sleep.
And we heard some testimony I read a note about a diaper rash. Tell us about that.
That diaper rash was really bad. It got to where it started getting blisters on her, and I told them about it. And then I told them that she had medicine at the pharmacy, and they said that I had to pay for it, and before they could go get it. But then I went to Georgia about it, and Georgia told me that no, that ain't that wasn't right. They were supposed to have that a week ago.
So you went to
Yes, I went to Georgia.
staff before Georgia,
Yes,
and they told you what?
they told me that I had to have money to go get it first.
Did you have any money to pay for?
No,
And I read about, were you also doing counseling while you were
yes,
there at Independence House?
and trauma counseling
Trauma for what?
for my past.
And I'm not gonna have you talk about that today, but did you have any trauma or diagnosis related to your pregnancy or giving birth?
Yes,
What was that?
I went in to labor early, but then they gave me a shot to stop my labor at 5 months. And I was 38 weeks. Now I was 36. And then they stopped my labor, and then then I fell in grease and stuff, and then the next day they took me to the hospital, and that's when I went in labor.
That affect how
Yes.
fragile the little girl was?
Mhm.
Was that going into while you were holding her?
Mhm.
Do you remember talking to Mr. Couch?
Yeah,
Who was he?
he's the therapist.
Postpartum, did he come with that?
Yeah.
I would hate to interfere, but are you leading the witness and is that hearsay? I just asked you, if you don't think it is, proceed. The Commonwealth's not gonna object.
Judge, I agree with
Then
you on
proceed,
both.
then proceed, then proceed.
Go ahead,
Yeah,
Mr. Cat.
Tim Couch is the therapist, and he did tell me that I was postpartum depression because I told him my diagnosis, how I felt and everything, and then he diagnosed me with it.
Amy, while you're at Independence House, you know, they told you, hey, don't do this. Did they give you any classes, any education, anything to train you for parenting? Are they doing those things?
Yeah, there is a class that we do, and it's parenting, but we hardly got to go to it because the woman kept canceling and stuff, so.
So you weren't even able to do that parenting class there?
Mm.
Good, that's all I have.
I've got no question.
I have a couple of questions here. I was looking through the records. There was an allegation that you picked the baby up by one arm rather than picking the baby up like babies are supposed to pick up, that you were co-sleeping improperly with bottles, getting the baby out of bed with one arm. What was the deal with that?
The one on thing is she was choking and it scared me, and it's just a reaction.
What was that?
She was choking. That's when she was premature. She couldn't hardly breathe. She already quit breathing on me once.
Hey, Mr. Stockton, you have, Mr. Payne, do you have any other witnesses?
No, Your Honor.
Mr. Stockton, do you have any rebuttal?
No.
You want to come up and make your argument?
Your Honor, the Commonwealth and the court is presented with this case because Ms. Burchett had a problem with methamphetamines. She had such a problem with methamphetamines, she endangered her child when she was pregnant using methamphetamines. You know, she wasn't punished by being sent to Independence House. The specialty court program was trying to protect her and the child. And then when she gets up there and the baby's born, the baby's a few weeks early. There's at least 10 to 12 instances where she's warned of co-sleeping with the baby. There's also instances documented in the record where she kicked the bassinet when the baby was in it. And then you have the issue where she's pulling the child up with her arm. I don't know if those two allegations are true or not, but I know the co-sleeping is sufficient to cause problem. You know, having a child is not about convenience. It's not about being able to sleep. I remember when my two children were up here and I couldn't sleep.
Wait a second, I'm having a party.
Yeah, I remember when my two children were born and I'd come to the office and I'd fall asleep in the afternoon because I couldn't sleep. Having a child is not about convenience. It's about protecting your child. And she was warned repeatedly, and she wouldn't follow the guidelines. Now, they can make the rehab out as the villain, but all they're trying to do is protect that child. And all the Commonwealth is trying to protect that child. Maybe she'll be old enough when she gets out of here that the child can help take care of herself, because Miss Burchett's proved she can't.
That'd all be a great argument if this was a juvenile dependency neglect action. But this is a receiving stolen problem case. That's what the initial charges were for. That's what the probation was for. And Ms. Burchett admittedly had a drug problem, went into specialty court to address that problem. Did what they said, go to rehab for 90 days. She stayed.
Let me ask you something.
Yes, Your Honor.
She took methamphetamine twice while she was here in court too, though.
Yes.
Okay, well, we'll skip that part, but go ahead.
And specialty court, again, I'm not gonna disagree with Mr. Stockton on trying to protect this mother and the child. So they send her to rehabilitation for, I think what was important, why I did want someone from specialty court, is for 90 days. She stayed 90 days. In fact, she stayed double that. And Judge, what it's telling is to go to rehab is to get off drugs. I understand it, and the court can exercise a paternal role, but if we're seeking to send a lady to prison for infractions that the Cabinet for Health and Family Services said, we're good.
They didn't say that.
Judge,
I've got the letter here, what they said. They said there was no intentional acts to harm the baby that they found out, so they couldn't open a case unless it was an intentional act. That doesn't mean that she was compliant or that they gave her Mother of the Year.
And Judge, here we stand, Ms. Burchett has already served over 60 days. What I'm asking for and what Ms. Burchett would ask for is for the court to impose that as a sanction and let her be with her child, get the services and the help she needs, and be a productive citizen. Judge, she got off drugs. She testified that she's been 10 months clean. There's been nothing in the record to contradict that. And one of the
Has
exceptions,
she been out? She hadn't been out, has she? She's
not
been
since
in jail.
rehabilitation.
Yes, she's been in rehabilitation and she's been in jail. It's easier to keep clean when you're in jail than it is when.
I had a week out.
Go ahead. Go ahead with your argument.
And Judge, again, the 60 days, if we're looking, does punishment fit the crime? There were no criminal charges brought up for dependency, neglect, abuse, again, Judge. So to circumvent that process and send her to prison on the underlying charges, Judge, she's not gonna get that 60 days back that she's already been away from her child. We're just asking that she be able to spend time with her daughter.
I'll take it under advisement.
Yes, sir.
Okay, now, that's all the transported prisoners, correct? You can transport them back. I'm gonna go ahead and go, Mr. Cross, you have a case?
No, right here.
John Brown?
No, that's not mine.
Well, he's on the list here. I thought he was, okay. Brett Carver. You want? Commonwealth versus Brett Carver. 23 CR 0039. Let Mr. Carver behind the microphone. Are you Brett Carver?
Yes, sir.
Born in 1976?
Yes, sir.
Last 4 digits, social security number 5893.
Yes, sir.
Okay. What's the Commonwealth have to say in this case?
Your Honor, we submitted a restitution order. Mr. Carver is supposed to have all restitution in this case paid in full by March the 28th, including the 5% clerk's fee. And if that's the case.
How much is the rest?
It's $212,000. And if he has that done, then the Commonwealth will dismiss the prejudice, again, will stipulate probable cause, and that's what the victim wants done in this case. If not, then we'll set it for trial.
Well, it's set for trial, but yes,
Well, I'm sorry, yeah, we'll just maintain the trial date.
yeah, we basically have the agreement. in
When
place.
is the trial date?
April, 17th? 23rd.
Okay, and when he's had the money in by?
I believe the 28th.
28th of March.
So
And
that's
I-
still 2 weeks before.
Yes, that's correct.
Yeah, I did speak to the lender last night.
All right, it's neither here nor there to me.
I'm sorry.
We don't need to publicly
Right.
talk about his business here.
Well,
That's his business where he gets the money.
I'm not one,
Well, I
well,
understand it. I'm just saying you don't have to tell me
Yes.
that, okay? It's his business where he gets the money. As long as he gets it legally, and if he doesn't get it legally, we'll address that some other time. So,
thank you.
thank you. I guess he'll be back here on, what was the trial date again?
April 23rd.
So you want him back here on April the 11th?
If it's paid, we'll enter an order of dismissal. If not, if I have any pretrial motions, we need to be back here.
Okay, you have any pretrial motions, it'll be on April 11th.
Understand, Your Honor. Based on what we're doing, we don't
You submit an order?
think that's accurate.
We will, once it's paid in full. We'll submit
Okay,
it.
is there an order submitted already?
Yes.
Restitution.
There is.
Restitution order,
So the
okay.
clerk can take.
That'll
the
be
money.
fine. That'll be fine. Thank you. Okay, Cody Smith. Is that your case, Mr. Whittenburg? Commonwealth versus Cody Smith. Are you Cody Smith?
Yes, sir.
Born in 1992? Last 4 digits, social security number 4867. We're here on a pretrial conference. What's the Commonwealth episode?
Your Honor, we need one more negotiation day.
What is your negotiation date?
Well, I think it'd be April 5th at 1 o'clock.
April 5th at 1 o'clock?
In Carver County, if there's no objection from the defendant. Is that possible for you?
Yeah, I can do that.
April 5th, is that gonna be all your Clinton County things are gonna be over there? April the 5th, in Cumberland County, 1 o'clock. Your next court date is April the 11th. Both of them are conditions of your bond, okay?
Thank you, Your Honor.
Mr. Cross, you have Derek Stockton on some expungement
Your
things.
Honor, I was his initial attorney, but I didn't finish the case.
Commonwealth has no objection.
Okay, make sure that we make a note to enter those.
Yeah, we
Angela Wallace. Angela Wallace,
Oh, well, she rehabbed.
The jail posted bond about when she had blamed that now.
Okay.
okay, we'll make sure they need to tell her she's supposed to be up here.
I'm
here.
You're there, okay, Commonwealth versus Angela Wallace, 24 CR 0005. Miss Wallace was born in 1972.
Yes,
Last four digits, social security number 7871.
yes, sir.
What do you got here, Mr. Stockton?
Mr. Kraus needs to enter a conflict waiver, I think, before we proceed on this case, because there was 65 grams of meth found at her residence. And her residence was also listed as an address by Joseph Wallace, who Mr. Kraus represented. So I'm asking him to get that entered so we can proceed with that case, if he's gonna represent both of them.
And I'm a little, Mr. Stockton and I have discussed this. I represented Mr. Wallace in his previous case, but it's my understanding you're going to charge Mr. Wallace in this.
It depends on Ms.
Yeah.
Wallace's position, if I'm
Yeah.
gonna charge Mr. Wallace or not.
I got you. So and plus she's also got something in Mr. Leverage's court, so
What is charged in Wayne County? Got, y'all look
it's
at it.
methamphetamine.
When,
It all happens.
okay, now, what I'm asking, was she out on bond in this court? In that other, infraction?
No, sir.
I don't believe so. No, I don't think so. She's been in rehab. She's currently in
What kind
rehab.
of bond is she,
For airport, she has a sure bond.
how much? You what?
For sure.
Are sure he's on the grand jury? Well, I'll schedule her to be present with an attorney on April 5th at 1 PM for negotiations in Cumberland County. And her next court appearance, April 11th. And I'm putting a hold on it down there until I figure out what's going on with all these cases. So jail, put a hold on her. Because I want to see what these Wayne County cases are and how they interrelate to our cases and what the time was and everything. So don't transport her until we tell you to, okay? I know you can't keep her. I'm talking about. Let's see. Yeah. Mr. Stockton, will you come up here just for a second? You, it's mute. Okay. Moving right along. Now that finishes, Mr. Whittenberg. Mr. Cross, do you have anybody else that's out of custody?
Don't believe I do.
They're in hold her.
It was in January.
You don't have anybody else out of custody? Okay, we're going to the Russell County Detention Center. Everybody else that's out of custody, you can come back here at 2:00. 2:00. That'll give us time to go through these in custody things. So if you're out of custody,
Judge, if I may.
I asked if anybody else had one. You're not listed. Do you have anybody? Who do you have? Okay, we'll do yours. No DPA listed, so I guess you're special counsel.
Conflict counsel.
Okay. Candace Tweedy. Commonwealth versus Candace Tweedy, 23 CR 0058. Are you Candace Tweedy? You born in 1997, last four digits, social security number 2464. This is a pretrial conference. What does the Commonwealth have to say?
Well, I've made enough.
Judge, there's a co-defendant in this matter.
Be ye yea or be ye nay on the offer?
At this point in time, we just received evidence yesterday with regard to the case. And so I haven't even been able to access
Just
it.
discovery, you just received?
That's correct. That's correct. And so we wouldn't ask for another pretrial conference date. I believe the co-defendant in this case will be filing a motion to suppress, and we will probably be joining in on that pretrial motion.
Who is the co-defendant?
John Brown. I thought he was gonna have it filed today, but I got word yesterday it wasn't going to, even though it's set for the docket.
April 5th at Burkesville for negotiation. Is that okay, Mr. Stockton?
That's fine.
And then the next, April the 11th. Okay?
Thank you.
Judge,
Yes.
can we call William Shekels? He's got a long drive back to treatment and he's just sentencing today.
For sentencing,
Yes.
William Shekels. Commonwealth versus William Shekels, 23 CR 0052. Are you William Shekels?
Yes, sir.
You born in 1979,
Yes, sir.
last four digits of social security number 9169.
Yes, sir.
Okay, you're here today for sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation Ferell?
Yes.
Is it correct?
Yes.
Is there any reason this gentleman should not be sentenced today?
No, Your Honor.
Upon plea of guilty, trafficking first degree should be sentenced to 6 years, probation 5 years. Showing enroll and complete a long-term rehab at Edgewater Recovery for minimum 6 months. What are the court costs? $155. I'll let you have some time on that. Start paying it $30 a month, 30 days after you're released.
Yes.
Thank you, Judge. All drug paraphernalia and contraband shall be disposed of. Okay, thank you very much.
Thank you.
Meet the probation parole officer there. Okay, let's go to Russell County Detention. Did we ever get North Point on there? Okay, Russell County, Ricky Ferell. Commonwealth versus Ricky Ferell, 23 CR 0056. Are you Ricky Ferell?
Yes, sir.
Okay, were you born in 2004?
Yes, sir.
Last four digits, social security number 2624.
Yes, sir.
Okay, you're here today on a pretrial conference. What do you have to say, counsel?
Judge, I believe we've reached a resolution in this matter and have a motion to enter a guilty plea put forward.
Mr. Stockton, you have a pretrial diversion or felony plea?
It's a pretrial diversion.
Okay, ma'am, I understand that you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes.
Are you the same person I identified a few minutes ago by your year of birth and 4 digits of your social security number?
Could you repeat that, please?
What's your year of birth
2004,
and the last 4 digits of your social security number?
2624.
Have you read the evidence the Commonwealth has against you? You believe you're fully informed about your case?
Yes.
Have you had plenty of time to talk to your attorney, and are you satisfied with his advice?
Yes, sir.
You understand that you do not have to enter a guilty plea today. You have
Yes,
certain
sir.
rights under the Kentucky and United States Constitution. I'm gonna go down through those rights, and at the end, I'm gonna ask you if you understand, okay?
Okay.
You have the right not to testify against yourself. No one can make you say anything. You have a right to speed trial by jury, the right to be represented by counsel at your jury trial. You have the right to confront and cross-examine all witnesses that call to testify against you. You have a right to produce evidence, a right to call your witnesses in your favor, have process issued to compel their attendance. You have a right to appeal this matter to higher court if you lose, and a right to require the Commonwealth prove beyond a reasonable doubt that you're guilty of charges against you. You understand by entering a plea today, give up those rights. You understand that?
Yes,
Now, I
sir.
may consider the Commonwealth's recommendation, or I can sentence you to any amount that is available under law. But if I impose a harsher sentence, you'll have a right to withdraw your guilty plea. I'm gonna ask you some qualifying questions here. Have you been pretrial diverted in the last 5 years?
No, sir.
You had a felony conviction in the last 10 years.
No, sir.
Currently on probation.
No.
You understand that if you successfully complete this diversion program, your case will be dismissed pretrial diverted. You understand that?
Yes, sir.
However, if you violate the terms of your agreement, be brought back before this court. If I avoid the pretrial diversion and pre-sentence investigation report done, you'll be a convicted felon. It can be used against you in sentencing in the future. You understand that?
Yes, sir.
Now, what does the Commonwealth say about this case?
Upon a plea of guilty to criminal abuse second degree, 2 counts, the defendant shall receive a sentence of 5 years on each count for a total of 5 years. Upon a plea of guilty to wanton endangerment first degree, 2 counts, the defendant shall receive a sentence of 5 years on each count for a total of 5 years. 2 5-year sentences shall run concurrently for a total of 5 years. Serve 150 days in jail with the balance pretrial diverted for 5 years supervised. Any contact with the victim shall be in accordance with the orders of Clinton District Court or Clinton District Court. The defendant shall have been served.
No, there's a
Oh.
companion DNA
Okay,
action.
thank you. Clinton District Court. The defendant shall enter and complete the Clinton Specialty Court Program. The defendant shall receive credit for time served. The defendant shall obtain gainful employment or do a minimum of 30 hours of community service until gainful employment is obtained, and the defendant agrees to have any and all evidence in the above style cases disposed of in a manner that's consistent with the laws of the Commonwealth and the holding agency.
Young lady, is that what you agreed to?
Yes, sir.
Are you pleading guilty because you committed the acts charged in the indictment as amended?
Yes, sir.
Doing so of your own free will?
Yes, sir.
Knowing your constitutional rights, explain to you, is it still your desire to allow the court to proceed to fix your punishment as recommended by law?
Yes.
If I may.
Young lady, is that your signature on there? Look up at the screen.
Yes, sir.
I'll accept the pretrial diversion agreement. When can she meet with probation pro?
Judge, she's a drug court case, so she probably will not be released until she is.
Okay, they'll be over.
Revocation.
Did they vote her yet?
No, that'll be assessed.
Okay, well, you wait over there and they'll come over and assess you for drug court and vote on you. As soon as they set you out for orientation, I'll let you out for jail, and then you'll have an opportunity to meet with the probation parole officer, okay?
Still likes 40 to
Thank
50
you.
days, but I don't have any objection to release or orientation.
Did you hear what the Commonwealth says? You have 40 or 50 days left, but if the orientation goes well, he'll consider signing an agreed order to let you out early if you go into drug court. You understand?
Thank you.
Okay, thank you.
Thank you, Judge. That's all I have.
Savannah Jackson. Savannah Jackson.
Yes, sir.
Are you Savannah Jackson?
Yes, sir.
Were you born in 1998?
Yes, sir.
The last four digits of your social security number 2524.
Yes, sir.
We're here in case number 24 CI 0007 for the purpose of arraignment. You have a right to remain silent. Your attorney is standing here. The grand jury of Clinton County has returned an indictment charging you with criminal abuse in the second degree, wanton endangerment in the first degree, possession of controlled substance in the first degree, possession of drug paraphernalia, and possession of controlled substance not in the original container. Counselor, you acknowledge the identity of your client, received the indictment, await formal reading and arraignment, enter plea not guilty, reserved all pre-trial motion.
Yes, Your Honor.
We schedule a negotiation conference for you on April the 5th in Burkesville. In April the 11th, you'll be back here in court. I'm signing a reciprocal discovery order that requires the Commonwealth to give your attorney information to help you prepare for your case. Here you go. Thank you very much.
We ever see you, Miss Jackson?
Darian Riddle,
What's that mean?
Darian Riddle, Commonwealth versus Darian Riddle, 23 CR 0062. Wayne County, if you're on there, we just have 2 to 3 more cases before we get to you. Mr. Riddle, you born in 1972.
Yes, sir.
Last 4 digits, social security number 4086.
Yes, sir.
We're here on 23 CR 006268. What's the Commonwealth have to say?
Your Honor, I have a witness that actually reported the incident. It's out from the 15th through the 24th of May, and I want to get a alternate trial.
Okay. Is this a 1-day trial?
Judge, I would anticipate, and this is one, I don't think we've had a time to properly negotiate this case. If Your Honor wanted to set a negotiation before a trial, there was 2 cases, and we negotiated the first theft case, not the
Is he a
second.
state prisoner?
He's currently a
He's
state prisoner. serving
and I've
time.
got one case where he allegedly stole property of his stepfather, and I've got another case that's set for trial where he was in possession of stolen property out of Tennessee. So if Mr. Pennington wants another negotiation day, I'll give it to you. I don't know if we're making progress or not, but
Okay, well, let's cancel the trial date and have him set for negotiation on April the 5th in Burton. Okay, your trial date is scheduled. They're gonna transport you on April 5th to Burkeville to negotiate both these cases, Mr. Riddle. Okay,
All right. Thank you.
Barry Rose. Commonwealth versus Barry Rose. 24 CR 003. Are you Barry Rose?
Yes, sir.
You born in 1978?
Yes, sir.
Last 4 digits of your social security number 8692.
Yes, sir.
Here today for the purpose of arraignment. You have a right to remain silent. You're represented by Mr. Cross, who's present at court. Grand jury of Clinton County returned an indictment charging you possession of controlled substance, first degree methamphetamine, possession of marijuana, and possession of drug paraphernalia. Mr. Cross, you acknowledge the identity of your client, received indictment, waive formal reading and arraignment, enter plea not guilty, reserving all pre-trial motion.
No, Your Honor, we have a partial guilty plea. We have a plea agreement on this case and also
Wait
on
just
an
a second.
information.
I've got to. You acknowledge the identity of
Yes.
your client and receipt of the indictment.
Yes,
Okay.
I do.
What are you gonna do about that?
I'm going to say we acknowledge both of those, and then I'm announcing to the court that we have a resolution of Mr. Rose's case.
Is that correct, Mr. Stockton? Where's Mr. Stockton?
We just have to put him on this, Your Honor.
Okay, what kind of plea is it?
It's a felony plea.
And Your Honor, there's an information on this as well, so I don't know if this adds to the
Well, let's return the information first. You have a copy of the information.
I had it if she doesn't.
I do.
What is the information? You'll read the information into the record.
I can, Your Honor. It says count 1, the Commonwealth Attorney charges that on or
You need
about.
to speak up a little bit.
Count one, the Commonwealth Attorney, charges that on or about February the 4th of 2024 in Cumberland County, Kentucky, it's supposed to be should be Clinton County, Kentucky, the above named defendant did commit the offense of failure to signal KRS 189.380, a violation. It should be Clinton District Court, case number 24F 12 against the peace and dignity of the Commonwealth of Kentucky. Count two, the Commonwealth Attorney charges that on or about the February 4th of 2024 in Clinton County, Kentucky, the above named defendant did commit the offense of driving on suspended operator's license KRS 186.620. Section 2, a Class B misdemeanor, Clinton District Court, case number 24F 12 against the peace and dignity of the Commonwealth of Kentucky. Count three, the Commonwealth Attorney charges that on or about February the 4th of 2024, the Clinton County, Kentucky, the above named defendant did commit the offense of possession of a controlled substance, first degree methamphetamine, KRS 218A.1415, Class D felony, Clinton District Court, case number 24F 12 against the peace and dignity of the Commonwealth of Kentucky. Count four, Commonwealth Attorney charges that on or about February the 4th of 2024, the Cumberland County, Kentucky, the above named defendant did commit the offense of operating a motor vehicle with alcohol concentration over above 0.08 or while under the influence of alcohol or other substances, first offense, KRS 189A.010, Class B misdemeanor, Clinton District Court, case number 24F 12 against the peace and dignity of the Commonwealth of Kentucky. And count five, Commonwealth Attorney charges that on or about February 4th of 2024 in Clinton County, Kentucky, the above named defendant did commit the offense of failure to maintain insurance on a motor vehicle as required by KRS Chapter 304, KRS 304.39-080, Class B misdemeanor, Clinton District Court, case number 24F 12 against the peace and dignity of the Commonwealth of Kentucky.
Now, all of those things and information included in the plea.
Yes, Your Honor.
Mr. Stockton, could I inquire, you come up along with your attorney to come up assistant here. I don't remember ever bringing any misdemeanors up from district court on an information. I do remember bringing felony cases up.
Yeah.
Can we bring misdemeanor cases up from district court on
That's
information?
something I've never thought of. I think you can since it's attached to the film. It was
Well,
made it
I'm not informed as where they are attached to the film.
Yeah, this all happened out of the same set of circumstances and occurrences. It's a good question. I don't know. But this is what happens. Mr. Cross is always prompt and he comes in the day before wanting to do a plea. And this is just a question that never occurred to me when we were scrambling around yesterday morning trying to get ready for the dock. That, I don't know. That's a good question. Are they bound over? Yeah, they're already bound over, so they're in front of us anyway. They're just not went to the grand jury. I think this case, now that I recall, was going to the grand jury today.
I believe you told me it was.
Yes.
And we're anxious to get it done because of a lot of health issues and things going on, Commissioner.
We're anxious to get it done because we probably got a good deal on it too.
Well, Your Honor, I think it's
It's your job, that's your job.
It's a reasonable resolution.
Huh? You know, we need the case number, even though if it's bound over, it hadn't been until the indictment's returned, it doesn't have a.
Well, the felony case number is 24F 12, which is all seen involved.
Yeah,
And then when I received it, it was showing 24, she already left.
yeah, but you hadn't received it, you won't receive it until today, till we accept the information.
What case number do I put on the information?
11.
Oh, 24 CR 00011 3 zeros and 11.
Many times I don't put zeros on there. I'll have to miss it.
Sort of thing that correction sends it back on zeros. Okay, sir, you've heard these additional charges. You need to sit back up so we can see your face. There you go. Is there a volume problem there? Can you hear what I'm saying?
Yes, sir. I just have to be close.
All right, hear him.
Yeah, we got a volume problem here somewhere.
Can't hear that.
Speak up, the speakers up here.
Yes, sir. I just have to be close.
There you go.
It's a system problem.
Have you heard the new charges that were entered by information?
Yes, sir.
Okay. Have you had plenty of time to discuss this matter with your attorney, and are you satisfied with his advice?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you, and are you fully informed about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea of guilty, I need to know that you fully understand your rights. You have a right,
Yes.
and I'll ask you at the end, what you do. You have the right not to testify against yourself. What can make you say anything, right to speak trial by jury, right to be represented by counsel at your jury trial, right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, right to call witnesses in your favor, right to appeal this matter at higher court if you lose, right to part of the Commonwealth prove on a reasonable doubt that you're guilty charged against you. You understand that by entering a guilty plea today, you give up all those rights. You understand that? Now, I may consider the Commonwealth's recommendation, but I may apply the range of sentence provided by law. I don't have to accept the recommendation. Prior to accepting the recommendation, I will wait a pre-sentence investigation report from probation bill. In the event that I do not accept the Commonwealth's recommendation, you decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. Ms. Gordon Anderson, what is the Commonwealth's recommendation?
Upon a plea of guilty to indictment number 24 CR 0003 for the charge of possession of a controlled substance first degree, the defendant shall receive a sentence of 2.5 years. Upon a plea of guilty to information indictment number 24 CR 00011 for the charge of possession of a controlled substance first degree methamphetamine, the defendant shall receive a sentence of 2.5 years. Upon a plea of guilty to information indictment number 24 CR 00011 for the charge of operating a motor vehicle with alcohol concentration of or above 0.08 or while under the influence of alcohol or other substances first offense, the defendant shall pay a $200 fine plus court costs. Upon a plea of guilty to information indictment number 24 CR 00011 for the charge of failure to maintain insurance on a motor vehicle as required by KRS Chapter 304 first offense, the defendant shall pay a $1,000 fine plus costs. The 2.5 year sentence in indictment number 24 CR 00003 and the 2.5 year sentence in information indictment number 24 CR 00011 shall run consecutively for a total of 5 years, serve 137 days in jail, with the balance probated for 5 years, supervised. The defendant shall receive credit for time served and shall be released at final sentencing on April 11th, 2024. Defendant shall be referred to a social service clinician and follow any recommendations of the clinician. Defendant shall obtain gainful employment or do a minimum of 30 hours per week until gainful employment is obtained. Defendant agrees to have any and all evidence forfeited and destroyed in a manner that is consistent with the laws of the Commonwealth and the holding agency in both the above style cases.
How do you catch all that? Sir, is that what you agreed to, sir?
Yes, sir.
Your Honor,
You realize,
may I interject? When we prepared the
I need to
documents,
speak up.
when we prepared the documents for Mr. Rose to sign, we put 30 days on the DUI concurrent. It's all just moved. That's what he has signed on the DUI plea form. So we can mark.
Mr. Stockton, are y'all listening to what's happening up here?
I put 30 days on the DUI plea form concurrent. It doesn't give him any additional time.
That's fine.
Yeah, I would think it would be. It doesn't
Is that
matter.
what you agreed to, sir?
Excuse me?
You understand by entering this plea, if you have future felony convictions, this could be used against you. And if you get another DUI in the future, that this could be used against you to enhance the DUIs, make them the penalty worse. You understand that?
Yes, sir, I understand it.
Is it still your desire to, enter this plea and allow the court to fix your punishment?
Yes, sir.
Okay, I'll order a pre-sentence investigation, to be done and have sentencing on April the 11th. If you give me the document, I'm going to identify his signature. So is that your signature?
Yes, sir, it is.
Okay. Well, the probation parole officer will be over to interview you soon, and then we'll see you here on April the 11th for sentencing, okay?
Yes, sir.
Anthony
Thank you.
Shaw. Commonwealth versus Anthony Shaw. Are you Anthony Shaw?
Yes, sir.
You born in 1990?
Yes, sir.
The last four digits, social security number 3671.
Yes, sir.
This is 24 CR 006 for a pretrial conference. What was the Commonwealth episode?
We have a plea, I think that.
We do
Is it felony or diversion?
felony.
Mr. Shaw, I've just been presented a document that says that you wish to enter a plea today. Is that correct?
Yes, sir.
Currently under the influence of drugs or alcohol?
No, sir.
Is the plea freely and voluntarily given?
Yes, sir.
Are you the same person we just identified a second ago as being born in 1990 and having the last four digits social security number 3671?
Yes, sir.
Discuss these charges with your attorney, and are you satisfied with his advice?
Yes, sir.
Judgment impaired today in any way?
No, sir.
Is your judgment impaired? Do you know what's going on? You're not impaired?
Yeah. No, I know what's going on.
Have you reviewed the evidence Commonwealth has against you? Feel like you're fully informed about your case?
Yes, sir.
Certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. Your right to speed trial of the jury. Your right to be represented by counsel at your jury trial. Your right to confront and cross-examine all witnesses called to testify against you. Your right to produce evidence. Your right to call witnesses in your favor. Right to appeal this matter to a higher court if you lose. And the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. You understand that any guilty plea, you give up all those rights. You understand that?
Yes, sir.
It's the Commonwealth's recommendation, but I mean, plain range of sentence allowed by law. However, if after receiving a pre-sentence investigation report, they decide to impose a harsher sentence, you have a right to withdraw your plea. You understand that?
Yes, sir.
What is the Commonwealth's recommendation, Mr. Stock?
Your Honor, Mr. Shaw plead guilty to possession of controlled substance, first degree, receive a sentence of 1 year to serve. A court cause of discretion in their court, and all evidence in this case be destroyed.
Is that what you agreed to, sir?
Yes, sir.
Are you entering, oh, excuse me, are you entering a guilty plea because you did commit the acts charged in the indictment as amended?
Yes, sir.
You didn't seal of your own free will.
Yes, sir.
Constitutional rights is it your desire to proceed with these, with this plea and allow the court to fix your punishment?
Yes, sir.
You understand that if you have a felony conviction in the future, it could be enhanced because of this plea?
Yes, sir.
He actually had,
If you'll hold the plea agreement up there, is that your signature on there? You have the agreement with you?
Anthony, do you have paperwork with you?
Yeah, I ain't got it with me. I just signed it.
Where is the
Yeah,
paper?
that's it.
Where is the paper?
Back over.
They faxed it back over there. The correction officers did.
We'll go over and see if we can find it. Is this
I'm
yours?
having the deputy bring it to us right now. But he faxed a copy over to the circuit clerk's office.
Prisoner, but he's been out of custody since he had his last PSI.
Mr. Bailiff, will you return this signature? Is that your signature on there, sir?
Yes, sir.
Yeah, I will accept the plea. Order pre-sentence investigation report and schedule sentencing for April the 11th.
Judge, if I may, I believe that Mr. Shaw, this will be an update.
No, because he has been, the last one was done on 7/17/23, but right after he was sentenced, he
We'll do an
absconded,
update.
so.
Yes, Your Honor.
We'll do update. Okay, thank you, Mr. Shaw.
Mhm. Thank you.
John Smith for arraignment.
Okay. Your Honor, we faxed a copy of this over to the clerk's office that they sent over from Mr. Shaw that had his signature on it.
Yes, we got it. Thank you so much. If you'll just, I guess, just forward the original over here by mail or something. And when our transportation officer comes over there, you can hand it to them and they can bring it back, okay?
Yes, sir, will do.
Thank you. John Smith, I understand, has been transported for evaluation. Is that correct?
Yes, Your Honor, he has been.
Mr.
He is
Stockton?
he's still out of the facility being evaluated.
I think ACPC over on, he just died, not in jail because he's in the Eastern State, that's my understanding. So,
Yes, was he in your facility for a while, John Smith?
Yes, Your Honor, he was.
He had some kind of issue and you sent him to Eastern State?
yes.
Okay, well,
Yes,
we'll
Your
just
Honor.
reschedule this on the docket at the Commonwealth and Defense.
And Judge, I have no objection insofar as I don't know if I've been formally appointed to this
You
case
have
yet.
now.
Thank you, Judge.
Chris Thrasher.
Your Honor, would you like for me to get Mr. Thrasher last due to the nature of his charges?
Joe Turner then.
All
Joe
right.
Turner. Commonwealth versus Joe Turner, 20 CR 0065. Are you Joe Turner,
Yes, sir.
born in 1965?
Yes, sir.
Last four digits of social security number 8351.
Yes, sir.
Ready for a motion for shock probation. In 20 CR 0065.
Well, Judge, this was a pro se shock motion
Or
or it was
give me the file.
or I didn't file the shock motion.
I don't know, we just, here it is, here. Do you have a copy of it, Mr. Stockton? I do. Speaking of 5th day, February, between Joey, chart of out, and that comes for. Sentence. Now, what was the underlying charge here?
He had a 5-year sentence on traffic and controlled substance first degree. There was a controlled drug by 7 grams of methamphetamine. And his probation was revoked because he absconded July 2022 and was arrested October the 30th of 2023. So about a year and 4 months, he was on abscond. So based on that, the Commonwealth's going to object. He's up for parole in October of this year.
Well, I'll take your motion under consideration, but I believe, Mr. Turner, you'd be better off getting parole than you would be shock probated. You understand what I'm saying? Conditions of
Yes,
your
sir.
parole. If you don't make parole, I will consider this to have been filed in time. Okay, and then I'll take a look at it at that time if the parole board doesn't give you a break on it, okay? So your motion was well filed and you've protected yourself as far as filing in a timely manner. So this is still in the works. We'll see what the parole board does. And if they don't, I'm directing your attorney of record to bring this back up, okay?
Yes, Your Honor.
Okay, thank you very much. Now let's go to Chris Thrasher.
Your Honor, may I inquire, could you all talk about John Smith while I was out?
Yeah, he's in the Eastern State.
Yeah,
Is it Eastern State?
I'm entering an appearance in that, and I.
Here's
think
Mr. Thrasher.
And I will enter a KCPC agree order on it.
Okay. Chris Thrasher,
You didn't hurry it back. You bet.
23 CR 0087. Hey, what do you have?
Your Honor, I have a petition.
You don't have to speak up now.
Sorry.
Because the pieces are bad.
I have a petition for change of venue. It's technically defective right now because I only have filed one affidavit, but I have the
Well,
second.
you're not gonna have an objection changed to you, are you? Are you, come over here?
Judge, the preference would be Clinton County. I believe that the the offense, if at all possible.
Yeah, so you do have an objection to change venue. I saw it.
Yes, sir.
And I'm not making a comment on whether I like or dislike your objection. I was just asking if you had an objection. You have one affidavit, it takes two.
And I had the second affidavit.
Who's the second affidavit?
It's from Lucas Avenue.
Presented to the court. Who is Lucas Abner? You know who Mr. Lucas Abner is?
I do, Your Honor. I've spoken to him several times.
What's his position?
He's the director of the Clinton County Emergency Medical Services.
Well, I just tell you, this gentleman's already been tried once here. Am I correct?
Yes, sir.
Very serious crime. This is a very serious crime too.
Yes, sir.
The affidavits are from two people who I think know the public well. Mr. Abner is the head of emergency. It should be, if a case is moved, it should be moved to a county in this judicial circuit that is contiguous. That would be Cumberland County. And I don't think the Commonwealth would be prejudiced by trial in Cumberland County. And the facility there, until we get our new facility, is much easier to handle a case if you got a bunch of things. So I'm going to grant you change of venue and change it to Cumberland County. Now, do we have a trial date?
We do not, Judge.
Is it already set a trial date?
I believe we are.
Judge, we filed a motion as well. I styled it as a motion in limine, essentially to.
Yeah, I noted it was a preemptive motion, a reverse motion.
Yes, sir. I wasn't exactly sure what to call it, so I defaulted to that and asking the court for an order or ruling allowing the testimony of Mr. Thrasher's now ex-wife, Stephanie, as to.
I believe the statute that you quoted is directly on point.
I have to concede that motion.
Okay, so I will grant your motion.
Thank you, Judge. Do you want me to tender an order to that?
I would tender an order to that effect.
Yes, sir.
If you got y'all's calendars out, do you have outside witnesses you need to bring in on this that you need some time out front?
There will be a few witnesses, Judge, so yes, sir.
What about June 17th and 18th?
Judge, I'm scheduled to be.
You have a conflict?
Well,
Just say
it's,
if you have a
it's
conflict.
vacation.
How about, July 15th and 16th?
We start a murder trial in Wayne County.
Okay.
Jackson. That's still how it is. Jackson, matter. Yeah. Congress and it's flowers. Need to be devoted. If
If we look at July 18th,
stipulate.
I can't judge, I'm sorry.
you have something scheduled for that?
A rate trial starts tonight.
What, and we already tried the 15th and 16th, right?
Yes, sir.
What about the 22nd and 23rd of July?
I can do that. That will be in Cumberland County.
Right. What did I say, the 22nd, 23rd, or 29th, 3rd? 22nd, 23rd is what I thought. Can't see my calendar when it, okay, now, is there any other motions you wanna, I guess, any pretrial motions should be filed, May the 2nd? Okay, yes, sir. That's the rule they. Evidently. Derby week is not sacred to you. We pre-trial motions. Okay,
Thank you, Judge.
thank you.
We'll be excused.
Yeah, absolutely. Thank you. Now, Mr. Thrasher, your case has been moved to Cumberland County and, your attorney will be talking to you sometime in the 3rd week in July. Okay?
Okay.
Thank you very much. Okay, now, do you have anybody else for us over there, Russell County?
No, Your Honor, that's all we had listed in the email, unless there's anybody else you need to see.
Thank you very much.
All righty, you all have a good day, Your Honor.
Do we have Wayne County on yet? Could y'all see if you can get Wayne County? Wayne County, there you are. Commonwealth versus David Carender, 22 CR 0062, 63, 64, and 22 CR 0078. Are you David Carender?
Yes, sir.
Born in 1993.
Yes, sir.
4-digit social security number 0416. We're here
Yes,
on
sir.
probation revocations. What's the Commonwealth have to say?
Your Honor, this is our motion to revoke probation.
You stand to the left a little bit, thank you.
Yeah, this is our motion to revoke probation on the allegation that he absconded.
You'll stipulate?
Well, Judge, if I may, I believe that the referral that I read from probation and parole was for services, so stipulation with referral to services, absolutely.
No, I'm not understanding what you're saying. Let's take some evidence here. Use your right hand. Swear the testimony you're about to give is the truth, whole truth, and nothing but the truth. Can you get centered behind the microphone here? Okay, you may inquire. State your name and with whom you're employed.
Officer Carson Payne, probation and parole officer for Clinton County for the Kentucky Department of Corrections.
Okay, you may inquire.
Are you familiar with David Carender?
I am.
Is he a defendant that you have been ordered to supervise?
He was supervised out of the Wayne County office by Officer Ashley Tucker. And I have her notes here to testify.
And when did he get under their supervision? Her supervision?
He began supervision on 7/13 of 2023.
You have any violations?
He did.
Okay, can you please tell us
Um,
the dates?
The first two violations, he failed to report on January the
You will
4th.
lower the thing so it won't block your voice, okay?
On January the 4th, 2024, the above failed to report to probation and parole as directed. Phone contact, the officer contacted him by phone, but no answer. On January 31st, the above failed to report as directed by a door hanger that was left at his last residence. Absconding as of January the 4th, 2024, the above failed to maintain contact with probation and parole. At this time, it is deemed that graduated sanctions are no longer appropriate. A check of justice exchange confirmed that he was not incarcerated at that time, and the officer requested a warrant.
So there were two instances where he did not report?
He missed his regular report day. After that, they went out and done a home visit on January the 30th and left a door hanger. When nobody's home, we have door hangers we hang on the door. And left it for him to be at the office on the next day, which was the 31st at 8 a.m., and he failed to report.
I don't have any other questions.
Officer, what's the referral there at the bottom line?
I don't have any referral, sir. Right here.
Oh, okay.
Revocation, requested revocation due to the above listed violations. The officer expect that a warrant be issued and the above be placed on docket for revocation upon service.
And what does revocation upon services mean?
A revocation hearing like we're having now.
Okay. And as far as the absconding,
Yes.
is there a note that David missed a February date?
No, because the warrant was already issued before then. He did not, the last time he reported to our office was in December.
Okay, and he didn't report in January
Yes,
and didn't have the opportunity to report February.
because the warrant was already issued.
So,
When you miss a report day, we get a warrant.
okay.
After we do the process, we go do a home visit. He didn't answer the door. He didn't report the next day. Either his choice or he didn't get it for some reason, or he may not be living there. We don't know that. But he didn't report, and when you don't report, we requested. That's process of probation.
And what you're doing is you're reading someone else's note, right?
Yes,
And that's, so you weren't actually supervising Mr. Kern.
I was not. I can get her on the phone. I can get her if you'd like her to testify.
Yeah, let's
She'd
go
be on
ahead.
in
You
a
wanna
couple
get, are
minutes.
you gonna get her on the phone? I've got all night. We can be here. But go ahead and we'll delay this one and get her on the phone.
Yeah.
We'll come back to you, sir. Look, Wayne County will call you when you wanna get him back on the line.
It'll be 2 minutes.
Hold on. We might get him sooner than that. Hold on.
Yes. She's getting ready to be off and.
You're long enough. Yeah.
Amazing. Can you send the link Ashley.tucker@ky.net?
Just get her on the phone.
Just one on phone?
Knock on the door and see if he's got the witness on the line.
If they'll hang on just for a few minutes, she'll be calling me right off.
Okay, we'll pass over the case. If y'all can just keep online, we'll be right back to you. Let's go to Clinton County Jail, and then we'll go right back to Wayne County. Clinton County, Tony Albertson. Come up versus Tony Albertson. Are you Tony Albertson?
Yes, Your Honor.
1984. Were you born in 1984?
Yes.
Last four digits of Social Security number 9471.
Yep.
We're here on a pretrial diversion revocation. What's the time of it?
Yes. Oh, okay. Never.
I want to know what it is.
It's our second motion to revoke pretrial diversion.
What are the grounds?
Absconding.
Okay, and you're stipulating.
That's
So
correct, Judge. There's some.
I'll revoke the pretrial diversion order pre-sentence.
Oh, and escape from jail. Just our allegations are.
Okay, is that a new charge?
Yes, Judge, and that's what I was gonna say. There's some pending cases that have been presented to the grand jury, so I think I discussed with talking about resolution on all the cases at once.
Well,
I
what
don't
I'll
know
do
if-
is I'll order a pre-sentence investigation report, see if y'all can wind it up. And we will, schedule it for sentencing on April the 11th. And we can do anything before April the 11th on April the 5th to negotiate the thing out, okay?
Yes,
So
I'll be-
April 5th on a negotiation day, April the 11th, negotiation day will be in Burksville.
be able to talk to you, Tony.
Terry Britt. Terry Britt. Commonwealth versus Terry Britt, 23 CR 00055. Are you Terry Britt?
Yes, Your Honor.
1975. Last four digits of Social Security number 0950.
Yes, Your Honor.
Here on pretrial conference. What's the Commonwealth have to say?
Hang on just a second.
Felony, please.
Yes, Your Honor.
Mr. Britt, I've just been informed that you wish to enter plea today. Is that correct?
Yes, Your Honor.
Plea under the influence of drugs or alcohol?
No.
Freely and voluntarily given.
Yes.
The same person identified in 23 CR 0055.
Yes.
Judgment impaired today in any way? Is your judgment impaired? You know what's going on here?
Yes.
You discuss this matter with your attorney. Are you satisfied with his advice?
Yes.
Review the evidence Commonwealth has. She believes about your case.
Yes.
Understand that you do not have to enter a guilty plea. You have certain rights. Before I can accept the plea of guilty, I need to know that you fully understand those rights. I'm going to go down through them. Ask you at the end if you understand, okay? You have a right not to fight against yourself. No one can make you say anything. You have a right to speak trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called and testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to a higher court if you lose, and the right to require the Commonwealth to prove on a reasonable doubt that you're guilty of the charge. You understand by entering your guilty plea today, you give up those rights. You understand that?
Yes, Your Honor.
So the Commonwealth's recommendation on that, my plea, I made a plain range of sentence for right law. I don't have to accept the recommendation. Prior to accepting the recommendation, I'll watch the pre-sentence investigation report from probation and parole. In the event that I decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and receive the trial. Ms. Gordon Anderson, what is the Commonwealth's recommendation?
Upon a plea of guilty of a handgun by a convicted felon, the defendant shall receive a sentence of 5 years, serve 171 days in jail, with the balance probated for 5 years supervised. The defendant shall receive credit for time served, shall be released at final sentencing on April 11, 2024. The defendant shall obtain gainful employment or do a minimum of 30 hours per week until gainful employment is obtained. The defendant agrees to have any and all evidence forfeited and destroyed in a manner that is consistent with the laws of the Commonwealth and the holding agency in the above style case.
Is that your understanding, sir, of the Commonwealth's recommendation?
Yes, Your Honor.
You plead guilty because you did commit the acts charged in the indictment as amended.
Yes, Your Honor.
Doing so of your own free will.
Yes.
Among your constitutional rights is still your desire to enter this plea to allow the court to fix your punishment in the provisions of law.
Yes, Your Honor.
Guilty pleas, convictions of felons could be enhanced for a sentence because of this plea. You retrieve. Is that your signature, sir?
Yes, sir.
I'll accept the guilty plea and order a pre-sentence investigation report done and hand it back over here. Sentencing will be on the 11th and everything goes well. We accept you to be released. Okay?
Your Honor, I would like to, at this point in time, on behalf of request to be released on home incarceration.
It's not part of the agreement. So.
Thank you.
Mr. Stockton reached the agreement. He's not here. Yes.
I've got Officer Anderson, or Officer Tucker, I'm sorry.
Okay, well, let's go back to that case. Wayne County, if you get David Carender, case 22 CR 0062, 63, 64, and 78. And if you'll just place it right here.
Officer Tucker, you are now on speakerphone with Judge Williams.
Okay, could you identify yourself, please?
Officer Ashley Tucker with Probation and Parole.
Hey, we're here on the case of Commonwealth of Kentucky versus David Carender, and the Commonwealth's going to inquire of you, okay?
Okay.
How are you employed?
With the Department of Corrections Division of Probation and Parole.
Okay, and as part of that role, were you assigned a David Carender to supervise?
Yes.
Do you know when his supervision began under you?
On July 6th of 2023, was when he was first placed on supervision out of Wayne Court. And then he was placed on supervision about 10 days later. So on July 13th from Clayton County.
Do you know of any violations that he had while he was under your supervision?
Yes, he absconded on January 4th. He failed to maintain contact with probation and parole. And failed to report as directed on January 4th. And then we conducted a home visit. Let's see, on January 30th, we conducted a home visit at the last reported address. And left a door hanger. There was no contact made, and he failed to report on 131 as directed by the hanger.
Prior to January the 4th, when was the last time that he had reported to you?
It would have been in December. I don't have that exact date in front of me.
Did he report to you at all, or did he make contact with you in February?
No.
And did, as part of his supervision, is he supposed to maintain a address as well as a phone number where you could be able to contact him?
Yes.
Okay. And as far as you know, the phone number that you called or the address that you went to, those are the ones that were reported to you by him?
The last ones that I had attempted to contact or home visit that I did would be what was the last on file, yes.
I don't have any other questions.
Officer Tucker, can you hear me okay?
Yes. Yes.
You were asked a question if David reported in February. Are you aware when he was picked up on the warrant?
I don't have that information in front of me at the moment.
So when you said he didn't report or contact you in February, you don't know if he was incarcerated at that time?
To my knowledge, he wasn't, but no, I don't have that in front of me at this time.
And just to be clear, Mr. Carender's also under your supervision out of a Wayne County case, right?
Yes, he is.
Okay. Was he revoked in those proceedings?
He's not been, He had one court appearance, this week for Wayne County, and they have not made a decision yet. They have wanted to see what Clinton County was going to do first.
And you said David reported in December.
December, yes, and then nothing in January.
If David had failed drug tests, those would be sanctions, correct?
Yes, if he had any, prior violations, then they would be listed.
And there's none listed, correct?
Correct.
So this was his first hiccup.
Yes, he absconded. This is his first violation, absconding, failure to report.
Thank you, officer.
No other questions?
He should be released.
Yes, Your Honor.
Thank you for calling in. Do you have any other
Thank you.
witnesses?
No other witnesses, Your Honor.
Okay, we'll call the witnesses.
Yes. David? Can you hear me?
Yes, sir. Yes, sir.
Bye.
I'm back at this microphone. Can you hear me now?
Yes, sir.
You raise your right hand, sir. You swear the testimony you're about to give is the truth, the whole truth, nothing but the truth.
Yes, sir.
State your name.
David Allen Carender.
Please.
David, I'll get right to the point. What happened in January this year? Why didn't you report on the 4th?
Sir, to be honest, I was between work and trying to take care of my kids and stuff. Like I just have got custody of my son back. To be honest, I missed the report date. And to be honest with the court here, this is the first time in 15 years that I've ever done good in my life at all. And it scared me when I missed the report date. Like, I just.
Hold on, David. David, we're not getting anything you're saying. You're going to slow down.
All right, to be honest, when I missed my report date, it scared me, and that's like it wasn't through the drug use or nothing. I still got 17 months of sobriety. I've got custody of my son back. I've got a job. My boss is calling.
Why didn't you report?
It was just a misunderstanding of it.
Wait, slow down. You're talking like a cartoon character. You're talking too fast. We cannot understand you, okay?
I apologize.
Why did you not report?
It just was I just honestly got mixed up on the dates. It wasn't I ain't got no reason behind it. It just I missed the date. When they come to the house and they hung the tag up, it scared me, and it's the first time I ain't never done good, sir. So I'm used to just being in trouble. Just to be honest,
Okay,
there's
David,
no.
Okay, David, you talked about work and got a job right now?
Yes, sir. I've got my boss's phone number. You can contact them at any time.
And David, were you paying all your restitution on these cases?
Yes, sir. I hadn't missed a payment.
You want to send him off?
Mr. Stockton wanted him to be revoked, which is what my notes are.
What's the circumstances? What's the underlying charge?
Receiving stolen
Yeah.
property.
Multiple cases received stolen property.
Tampering, criminal mischief, and arson. That's the charge. That's what I've got, Clinton.
Sure. Well, I don't remember the arson, but.
How much time does he have?
Judge, this was a 12-year sentence.
Yeah, for arson, no receiving stolen property.
It was a concurrent sentence with the multiple charges, Judge. And again, I don't know, Mr. Carender's working full-time, paying his restitution, something a lot of my clients don't. Judge, I think again, it's to the detriment, in this case, to the victim.
I had the same sort of clientele you did, so I understand. You know, I don't think that we can necessarily measure what's expected of society by former clientele and the present clientele.
Judge, according to my check, Mr. Carender is got about a month in at this time.
Month in what? Since
He's got 18 days.
What is probation parole?
Judge, if they don't report, we can't supervise them.
Your Honor, if I may. This was just a hiccup, sir. It was just, like I said, I can stick back and I promise it won't happen again. I gave 7 months of perfect everything. It just was a hiccup, sir.
What I'm gonna do is I'm gonna give him a 60-day sanction. 60-day sanction, 30 days of it's already been, he's been over there 30. You're gonna get 30 more days.
He's been in 18 days, Judge.
18 days. I'm gonna give you a 60-day sanction. Will you have your job at the end of 60 days?
I should, I don't know. I got a question.
To make sure that you have your job.
I got a question, Your Honor. Would the Commonwealth be opposed to me doing my 60-day sanction on house arrest so I could work?
No,
I just haven't gotten custody of my son.
no.
Pushing it.
Okay, sorry.
I'll
I'm
get
sorry.
on top of you, David, and we'll talk.
All right, thank you. All right, thank you.
60-day sanction.
Yes, Your Honor.
And before that sanction is over, I'll hold an abeyance, but I'm gonna revoke him, give proof to the Commonwealth Attorney's Office that he has a job ready when he's coming out into probation parole. If he's got a job lined up, David, I'm gonna tell you what. You know, you missed a bullet today, man.
Yes, sir.
I don't want you spitting on the sidewalk. If somebody.
Yes, sir.
You live at the foot of the cross. You understand what I'm saying?
Yes, sir.
Okay, thank you very much. Wayne,
Thank you, sir.
for your cooperation over there.
Judge, do you want this as an alternative sentence with a pen entered
Yes.
for a total of 60 days?
Right. Okay, I guess we're going back to Clinton County Jail now. The grand jury wants to come in. Mr. Probation and Parole Officer, you abscond from the, Mr. Bailiff, will you go out and get the grand jury here? Mr. Cross, won't you come back over here and sit down? I know you like to shake hands with all the grand jury when they go by. We'll just have a seat back over. All rise to the grand jury, please. Okay, everyone can be seated. Everyone can be seated. Who's the foreperson of the grand jury? Who's the foreperson of the grand jury? Yeah, ma'am. Did 9 or more of y'all agree on each one of these things that you have in your hand there?
Yes, sir.
Could you present it to the bailiff? I have to constantly look down at my calendar to realize it's already like the first week of March is already gone. And I'm just barely used to doing 2024 now. You know, it takes a little while, so. Some of you younger members of the grand jury will get, appreciate that more later on in life about how quick these days fly by. But okay, well, it looks like everything is in order here. For those people that are already in custody, I'll probably issue summons or arrest warrants. If they are not in custody, we'll issue arrest warrants. Take a look at their record to see if they are flight risk or if they're a danger to themselves or other people, and we'll set bonds accordingly and conditions on their release. It's very important, as I said, for you not to discuss what happened in the grand jury with anyone. Could endanger someone's life, or some people might decide to get, as my grandfather used to say, scarce. They get a little scarce, you know, have a hard time to find. So the next time that you are asked to come back here will be April 11th. And that still will be 4 days prior to your income tax being due. So y'all still be pretty happy if you don't haven't filed yet. So the only reason you could be called back is in case of riot or insurrection or emergency. And the days we live in, who knows whether we're going to have an insurrection or not. You can't really tell, can you? So I thank you for your service. You play an integral part of the Justice Center, of the justice system here. And you are now released for the day. If any of you need any work releases or excuses or anything, go over to the Mr. Staten's office and they'll be glad to take care of you. All rise for the grand jury and they'll be excused. Okay, thank you very much. Everyone can see we return to the criminal docket from Clinton County Jail. Dylan Flowers. Dylan Flowers. Commonwealth versus Dylan Flowers. 18 CR 00073. Are you Dylan Flowers?
Yes, sir, I am.
Born in 1991.
Yes, sir.
Last 4 digits social security number 4226.
Yep.
Okay. What does the Commonwealth have to say, Ms. Gordon Anderson?
Yes, Your Honor. This is our motion to revoke pretrial diversion.
Okay. Could you give me some facts behind
I can, Your Honor. He was terminated from drug court on January the 10th of 2022 through February the 15th of 2024. He absconded. He had 3 positive tests for meth and some diluted tests.
You want to stipulate?
Yes, Your Honor, we're stipulating.
And we will revoke the pretrial diversion order pre-sentence investigation report to be done by probation and parole and appear back here on April the 11th. And your attorney will be to talk to see what sort of arguments you'll make on that day as far as situation. For sentencing. Tony LaHorn. Tony, how do you pronounce it? Lohorn or Lahorn?
Horn.
Okay. This is Tony LaHorn, 20 CR 0021 and 20 CR 0022. Mr. LaHorn, were you born in 1984?
Sir.
Last 4 digits, social security number 3893.
Yes, Your Honor.
It's Gordon Anderson. What do y'all have to say?
This is our motion to revoke probation. The allegation is that he absconded May of last year.
I'll stipulate, Your Honor.
Stipulation, probation, revocation is granted. We'll revoke the probation. Okay, Dylan Murphy. Dylan Murphy, pretrial conference. Commonwealth versus Dylan Murphy, 23 CR 0057. Are you Dylan Murphy?
Yes, Your Honor.
You born in 1996?
Yes.
The last 4 digits of social security number 1303.
Yes.
What does the Commonwealth have to say in this case?
We have a diversion for Your Honor.
Okay. Motion's been tendered, sir, that you wish to enter a plea today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No.
This plea freely and voluntarily given.
Yes.
Are you the same person we identified in 23 CR 0057 just a few minutes ago?
Yes.
Discuss this case with your attorney. Are you satisfied with his advice?
Yes.
Your judgment impaired today in any way?
No.
Have you reviewed the evidence the Commonwealth has against you? You believe you're fully informed about your case?
Yes.
You do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. You have a right, and I'll go over them with you in just at the end, okay? You have a right not to testify against yourself. No one can make you say anything. Right to speed trial by jury, right to be represented by counsel at your jury trial, right to confront and cross-examine all witnesses called testify against you, right to produce evidence, right to call witnesses on your own, and have process issued to compel their attendance. You have the right to appeal this matter to higher court if you lose, and the right to private Commonwealth prove on a reasonable doubt that you're guilty of the charge. You understand that by entering a guilty plea today, you give up all those rights. You understand that?
Yes, sir.
Now, I may consider the Commonwealth's recommendation, but I may oppose any sentence provided by law. However, if I give you more harsh punishment than you have agreed to, you have a right to withdraw your plea. Now, I'm going to ask you some qualifying questions, please. Have you been diverted in the last 5 years?
No.
Any felonies in the past 10 years?
No.
Are you currently on probation?
No.
You understand if you complete the diversion program, the charges will be dismissed pre-trial verdict. The case will be, you can have your record expunged as if it never happened. You understand that?
Yes.
If you fail to complete the program, you'll be brought back in front of me, and I feel like you have violated your pre-trial diversion. I revoke it, order pre-sentence investigation report. Have you sentenced at that juncture? You would be a convicted felon. This could be, it could be used against you in the future for more serious sentence and a persistent felony offender law. You understand that?
Yes.
Okay. Are you pleading guilty because you did commit the acts in the indictment as amended?
Yes.
Okay. Knowing your constitutional rights, still your desire to give up those rights and allow the court to fix your punishment. Now, have you gone over the agreement yet on the record? You did.
No, Your Honor.
Okay, go over the agreement.
Okay. Upon a plea of guilty to criminal abuse, second degree, 2 counts, the defendant shall receive a sentence of 5 years on each count for a total of 5 years. Upon a plea of guilty to wanton endangerment, first degree, 2 counts, the defendant shall receive a sentence of 5 years on each count for a total of 5 years. The 2 5-year sentences shall run concurrently for a total of 5 years, serve 150 days in jail with the balance pretrial diverted for 5 years supervised. Any contact with the victim shall be in accordance with the orders of Clinton District Court. The defendant shall enter and complete the Clinton Specialty Court Program. The defendant shall receive credit for time served. The defendant shall obtain gainful employment or do a minimum of 30 hours per week of community service until gainful employment is obtained. The defendant agrees to have any and all evidence in the above style cases disposed of in a manner that is consistent with the laws of the Commonwealth and the holding agency.
Give me a little flavor of this case.
Oh, let's see.
And Your Honor, if I may take the lead, I think we talked about this earlier. Mr. Murphy is a co-defendant with Ms. Ferell. She entered a plea earlier. This was a case where children had tested positive for a substance. There's currently, both individuals are in District 4. I'm not sure in front of which judge, but that's the reference to District 4 matter as far as interaction. And Judge White, Ms. Ferell, Mr. Murphy is going into specialty court.
Is this your signature there, sir?
Yes.
Yeah.
I'll accept the plea. They'll be over to evaluate you and assess you for specialty court. And we'll see what happens from that, okay?
Okay.
Thank you, Judge. David.
Jason Murphy. Come over to Jason Murphy. 20 CR 0001. Are you Jason Murphy?
Sir.
Born in 1998.
Sir.
Last 4 digits, social security number 6784.
Yes, sir.
You're here on a pretrial diversion revocation. What does the Commonwealth have to say, Ms. Gordon Anderson?
Yes, this was our second motion to revoke, but I believe that he's going to be stipulating, and Mr. Stockton had just asked for a sanction of 30 days. I think he's been in
Tell me
already.
what happened.
I doubt if Miss Anderson has knowledge, Your Honor. I'll be
Yeah.
happy to advise the court of what it is.
Say he missed.
She just shot in.
Yeah.
Your Honor. Oh.
He completed drug court. He was on inactive probation. He received a new charge. And
What was the new charge?
the new charge was a warrant for wanton endangerment. He was supposed to have a AR-15. I contacted him, he reported to our office. We put him in cuffs, took him to his house, searched his house. We found 2 rounds of ammunition, which were, they were pistol caliber. One was a 243, I think. And another round of ammunition, maybe a 22 and a handgun round. And searched his house, then we found marijuana leaves in the attic and some seeds, no active drugs. It was not seeds and remnants of where they had harvested marijuana.
And I think the reason why Mr. Stockton was in agreement to let him be sanctioned, and to let him go under active supervision is because the, victim in that case is John Smith, I believe, that's been sent to Eastern State. So
Correct. And
that's why.
And the charge has already been amended to a misdemeanor, and I believe it's withering and will die. The original.
And I think that's what Mr. Stockton,
Criminal.
reason why his position is this, to just sanction.
I want to commend y'all on research. Y'all really thorough. I think 2 grand of ammunition and bleeds and everything. What tells my people that be really, really careful.
Well, if people will comply with the law about handguns and ammunition, actually possession of ammunition is a violation too.
A little harder to.
Well, let's don't continue. I know what your opinion is as far as convicted felons having, firearms. You and I are not of the same opinion of that, so there's no reason.
The ammunition, Judge, was a 223, 4 rounds of 22.
Yeah.
Which was not the weapon that
Okay.
was alleged to have.
Yeah. It's ammunition and it's violation. And you want to do what kind of sanction?
I think Mr. Stockton said that he's already been in on 30 days, just to sanctioning what time he has served on the 30 days, and then let him go under active supervision. Okay.
Well, sir, I want to tell you, you don't need to have any firearms around you. And let's talk about it, and I don't want you to say anything right now that would incriminate you. You understand what I'm saying? You be careful what you say. If I find you out here and they report you got some kind of attack rifle or any other kind of long gun or pistol or anything, you're gone. You understand that?
Yes, sir.
Okay. Okay, I'll submit the order.
Jason, as soon as you get released, sir, report straight to the probation and parole office to see me, okay?
Okay, thank you.
Lloyd Owens. Commonwealth versus Lloyd Owens. 24 CR 0004. Are you Lloyd Owens?
Yeah.
What we got here? A motion to motion to respond.
Mr. Stockton is just needing another negotiation day for this one.
Well, in Burkesville, it's the 5th. April 5th at 1 p.m.
Your Honor, we did have it was set for bond reduction today. I wish Mr. Stockton was present on this one because he, no disrespect to Ms. Gordon Anderson, but he understands, I believe, the underlying issues in this case. If I could explain to the court what's happened on this, the court might be willing to.
Well, I'm not, I think what you'll need to get a hold of, Mr. Stockton, and if y'all want to try to reach some kind of agreement on it, I'll consider that. But.
He let me know 10,000 cash bond and home incarceration.
That's fine.
Okay.
Yeah,
I have a note on bond. It just says $10,000 cash bond and home incarceration.
What's he charged?
Your Honor, he has 2 counts of wanton endangerment the court initially set a $10,000 cash bond,
Yeah.
and then there's a
Reported to be back out in the area.
It is an allegation that he did violate an EPO. There's a misdemeanor charge on that. That one is, as this case is, vigorously defended. Sometimes you come in here and you don't have much defense, and sometimes you do. But he'll make a $10,000 bond and do home
We
incarceration.
have an ankle bracelet on.
He wanted it to be. Got it.
$10,000 cash bond, ankle bracelet, curfew, home, church, doctors. He doesn't work this.
He does work part-time, Your Honor. He's on Social Security and he does do some work. I'm sorry.
He doesn't need to be out gobbling around, moving around. I mean, he needs to be home, church, work. If he's moving around, every time he'd be out, we'd say he's on the way to work or something or something.
Well, we'll accept that at this point in time, Your Honor. We may
Thank you
ask
for being
that.
so understanding.
Thank you.
Michael Taylor.
Bring on KCPC on him, Your Honor.
Okay. Christopher Young. Christopher Young. Commonwealth of Kentucky versus Christopher Young, 23 CR 0018 0023 0028. What do you have, Ms. Gordon Anderson?
Motion to revoke pretrial diversion, allegations he was terminated from drug court and he had multiple diluted tests.
You gonna stipulate?
Yes, Your Honor, we spoke to Mr. Young and we will stipulate.
Is this a pretrial diversion revocation or probation revocation? So it's wrong on the dock.
Pretrial diversion.
Yeah, we'll revoke pretrial diversion or precincts investigation board done probation and parole scheduling here on April the 11th for sentencing. Now, is there anybody else down there at the jail that we need to talk to?
Michael Ritchie.
He's not on the docket. What's the deal on Michael Ritchie?
Judge, I filed a motion, electronically filed a motion to review.
Review what?
Judge, this is a case where you were waiting for a resolution in the underlying district court case and you were going to default to Judge Lawson. Mr. Ritchie's underlying district court case has been resolved, been pretrial diverted.
What was the underlying?
In Judge Lawson's court, alleged violation of the EPO DVO and assault force.
And what happened?
It was pretrial diverted for a period of 1 year.
Well, I mean, so there was an admission that it was pretrial diverted.
Judge, not in district court, but you know, district court does their diversion where there's a.
Well, I'm not gonna make a decision. What do y'all know about this, Ms. Gordon Anderson? Did you hear what council just said about what happened in district court? We'll continue this to April 11th.
Judge, if I may, could we be heard on this next week in Monroe County?
I have no objection to that, since Mr. Stockton will be there, and since he's not here. This gentleman the benefit of the doubt, here next Thursday in Monroe County. You make sure he gets the Zoom notice to be here. Mr. Stockton had to leave early today, Mr. Young. He had a doctor's appointment, and your attorney says Mr. Stockton has some knowledge of your case. So rather than wait till next month, we're gonna allow you to be heard, especially next Thursday, and give you the benefit of the doubt on this, okay? Okay, thank you. And is there anyone else down there? It's not. Do what?
That was Mr. Ritchie, not Mr.
That was
Young.
Mr. Ritchie. I called him Mr. Young by mistake because that was the last one on the docket, so it's Mr. Ritchie. Okay, is there anyone else down there in the jail? Now, do we have any other matter except those 2 o'clock live people?
Your Honor, case of Michael Likens is on the docket today. He is not yet before the court.
Well, where is he?
He's in Indiana. And
Well, I mean, I have no, is he on the docket? The live docket at 2 o'clock?
Well, he's on the, yeah, he'd be on the 2 o'clock docket.
Well, when he's not here, then I will announce that he's never been served, so they'll need to put him in NCIC and find him.
Judge, could I have an opportunity to explain his situation, please?
No.
Okay.
Okay, here's what I want you to do. I want you to talk to the Commonwealth about it, because it's not on the docket. I know, but I've got to have, well, it's not, you're not in front of me here, so it'll become at 2 o'clock. When I call this case, the Commonwealth will be prepared for it.
That's fine.
Okay? I just don't want to get it out of order. Okay. Is there anything else? I guess till 1 o'clock, is that correct? Thank you. Let's go off here.
Sure, what is it? What is it?
Is that right?
No.
Mute. Reorder in Harvard. Cabinet versus Hall.
Judge, in this case, the non-custodial parent has been ordered to pay $216 a month on current, $40 a month on arrears. As of right now, the balance is $1,080. There's been no payments to date, and we were asking if $500 could be paid by April the 10th.
I've never received anything other than in the mail what I just paid to come here today. That's the reason. I brought my award letter somewhere, draw Social Security, SSI, 539 monthly. If y'all wanna look at it.
Sure.
Yeah, just bring our SSI.
Pass
Judge,
over
we're gonna
this-
pass that. It was.
Pass over to April the 11th, and y'all go down and work with the county attorney's office.
Just wait up.
Cabinet versus Gray.
Judge, we have an agreed order in that case.
Cabinet versus Jones. Laura Jones.
Miss Jones, this is over. Judge, we have an agreed order in this case. But this is just state.
Okay, so this is where I sent it from.
We'll make it a lot easier. This one.
You got it?
Yep.
Okay.
Notary finished here.
Bring order. 21 CI 00164. And then the last case, no, it's Cooksey. Cooksey versus Cooksey.
Judge, in this case, the non-custodial parents ordered to pay $208 a month on current, 50 on arrears. And we're asking that $1,000 be paid by April 10th. The balance is $5,500.19.
Okay. And Cabinet versus Guthrie.
Great order, Your Honor.
Okay, thank you very much.
Thanks, Judge.
Okay, we have the 1:30 docket. If there are any parties that have both sides here that want to get ahead of the queue, we can do that. If not, let's go off the record. Versus Lakeside and Boat Storage LLC. What do you have here?
Your Honor, this is my motion, on behalf of Lakeside Boat Storage. But before I start it, questions, have you read the motion? If not, I'll do a longer version.
We'll do a longer version, even though I have read the motion.
All right. All right, so what we have here is two neighboring properties. Mr. McCracken owns one piece of property. At the time in issue, Lakeside owned another piece. Mr. McCracken sold a portion of his land back in 2011. And subsequently it wound up in 2014 in the hands of Lakeside. And in the deeds with those transfers, there was by letter of the deed, a 25-foot wide ingress, egress easement along one side of the property as in our motions. after Lakeside, bought the property and started developing an RV park, which is currently in construction. The claim brought against Lakeside is that it has interfered improperly with that easement and, interfered with the plaintiff's rights on that easement. We believe the facts of the law are clear that that has not occurred and that the court could rule at this time. And let me start here so the core question is, under the language of the deed, it's a 25-foot egress easement. So before the work began on the property, there was the area in issue was a wooded, hilly property line. It was only accessible by foot. It was not usable by car. Even on foot, it was a difficulty. So what Lakeside did after buying the property.
You have retaining wall, didn't you? So
No, it was a hillside. It was a hilly area with trees and stuff, but it was only accessible by foot, that 25-foot territory. So after Lakeside bought it, they put a road from, where the easement begins at the county road, excuse me, all the way back to his property. So that now there is a roadway on the property that can be traveled from the front of the property to the back. So it's our position, and believe that the facts from the visual evidence is clear that the ingress egress easement has in fact not just been maintained, but it's been improved. And we both agree, on the law here. There's a case called Wells versus Sonor, excuse me. And it says that a landowner can unilaterally modify the location of a roadway easement such as this, so long as it does not change the beginning and ending point and does not result in a material inconvenience of the easement holders. So
I thought I saw some big rock that had been laid somewhere that looked like a retaining wall.
what they did was it was a dirt hillside and now it's a rock.
Okay, I see it.
But
I remember seeing it.
It was a hillside before, it's a hillside still. But what has happened now is there's a roadway from the road to the back. So the beginning and end of the easement has been maintained.
What do you say about it, Mr. Cross?
Your Honor, I have a lot to say.
Let's try to say this concisely as possible.
Succinctly and accurately. Bob McCracken sold this property in 2011. He had Greg Talbot draft a meets and bounds description of an easement along I'd call it the southern end of the property, adjoining the property of Shouse, S-H-O-U-S-E. Mr. Wingfield is correct. The easement area was undisturbed. It wasn't being utilized at that time for McCracken. Because what McCracken's long-term plans were is he would utilize an easement there next to the Shouse property and likely be able to go into a cooperative venture with them to access his remaining property in the rear of what he sold.
That he had retained.
Yes, yes. Now, this is not an easement by necessity. He has another way to go in. But when Bob priced it to Figueredo, who sold to Lakeside, he did it with the intention.
Bob is Robert McCracken.
Robert McCracken, known as Big Bob here in Clinton County. When you say Big Bob, I bet everybody knows who he is. But he
stayed behind the microphone.
He wanted to utilize this, and he's not.
So you've got a specifically surveyed
Yes.
easement that you have, and what Lakeside is wanting to do is they're wanting to deviate from that specifically described easement, saying that they have a right to relocate an easement if it serves the same purpose to the property. Is that what?
And it does not materially inconvenience McCracken. Now, Kentucky is a minority state. You can do that in Kentucky if it doesn't basically defeat the purpose of the easement, inconvenience the person that holds the easement. There's two aspects of inconvenience. Number one, we can never, if they can move the easement, we could never have a joint easement with Shouse, and we only kept 25 feet, so it wouldn't be big enough for a county road anyway. But if you had 25 feet from Shouse, you'd have plenty of room. And McCracken does not want he or his people to drive through an RV park. And you've got RV spots here, you've got RV spots there, and you wind through it, and lo and behold,
So his easement was on the exterior of their property.
Yes.
Now it's taken interior with things located on both sides.
Correct. And I think.
And
the
he
sub-
could use his easement and expand his easement by adding property on his own side if he was so inclined. Like
Well-
he had 25 and he wanted 10 more feet, he could use his own property.
He doesn't own it at this point in time, but he's very close to these people, and that was the long-term.
Did he own it when it was created?
No, he didn't own that adjacent tract,
Yeah.
but
okay.
that was his plan, and it's been discussed, and there'll be proof at trial for Michelle's to come in and talk about that. Now, where their summary judgment motion fails is they talk about defeating the purpose and inconvenience, and that is not up to them to decide. It's up to the court to listen to what McCracken has to say. McCracken has filed an affidavit with their response, and McCracken says this ain't what he wanted. This is not where he kept it. This is not why he kept it there. McCracken doesn't want it moved. It doesn't matter that they've spent all this money to try to improve it. We could get into when this case is tried, we'll get into the fact that.
Well, since he didn't own let me ask you a question.
Yeah.
Since he didn't own the adjoining property,
Yes,
I'm not saying I'm not gonna buy into your argument, but it would seem like the argument would be stronger if he owned the adjoining property and he had 25-foot easement adjacent to the property that he owned, so that he knew he could improve or at least keep people off of by virtue of that easement. So
it would be a stronger argument, but if he'd owned the adjacent property, the easement would never have been here anyway. It'd been over on the farther edge. So it's not the fact that he didn't own it, it's what was Mr. Cracken's intent.
Would Lakeside have to do some reconstruction of a road or anything to reestablish that 25-foot easement that you claim?
And that's what we asked them to do.
Would you have to do that?
Yes, Your Honor, and if I may, the problem,
I'm
sorry, the problem with their argument is they argue what he planned to do with the property. As you pointed out, he planned to do things, but he hadn't actually bought property rights in the neighboring property. The deed itself simply says, and I quote, being a 25-foot wide egress easement. That's all it says. It doesn't say anything about a right for him to develop later on the property.
Does it by survey identify where the easement is?
I believe it does, Your Honor.
See, that, I find that to be problematic.
But it's only ingress, egress. It stores no other rights. So as a property.
Well, ingress and egress is just as big a right as fee ownership. And the location of ingress and egress is a factual issue as to whether or not what their intent was and what he wanted it for. And if they claim that when you moved it, it defeated the purpose of them getting it, then that a factual determination?
No, Your Honor, because McCracken cannot now define what is recorded in the document. The document records it's a 25-foot ingress, egress easement. So by law, what we had to honor was the beginning and end of that easement. And by what we did, we honored the beginning and the end of that easement. And he can fully now go from the front of the property to the back of the property, now in a vehicle, whereas before it was only on foot. What he planned to do in his mind doesn't matter. What matters is what is in the document, ingress, egress. We started at the beginning of the property.
Well, I've done real estate stuff my whole life and all kinds of easements and, all kinds of, boundary line disputes and, adverse possession and all those sort of things. But I'm a little surprised if you have a defined by survey easement and someone can alter it if it's just defined by beginning and end. I'm a little surprised by that.
And we're not talking a major alteration on it. It's simply a bump out into the property and into the back.
A major alteration is
I
kind of
bring
like
laugh at that.
minor surgery. That's surgery on somebody else.
It's not as if, I don't want the implication to be that we're now directing him to the middle of the property. We are simply creating a defined roadway that goes from beginning on one point of the easement and ends at his property, the back at the end of the easement.
So you're deciding where the easement is because you're the owner of the.
But under Kentucky law, that's our right.
Well, I mean, that's what you say. I don't
But
deny it, I haven't done any research on that particular thing except what you say.
Your Honor,
Why do you say that that's not Kentucky?
they've got, no pun intended, a hill to climb to prove that they can move it and not affect McCracken's intent in creating the easement and
You
his
have a
long-term
case on
purpose.
that, on the intent? You have a case on
Yeah,
the intent?
we cite basically the same case.
Yeah.
And what I'm
Just reading
saying,
it differently.
yeah, well, Mr. Wingfield, with all due respect, takes the position, it's up to us to move it. And as long as it starts the same
Who's
place and
us?
ends the
You're
same
talking
place,
about-
it's fine.
You're
And,
talking
and
about
that's
Big
not,
Bob? It's up to Big Bob to move it,
well,
what you call him?
my friend Big Bob had a definite purpose for putting the 25-foot easement there, and it's defeated by that.
Well, here's the thing about that purpose argument. Is that in the case? Is the purpose?
It's the intent, the
No,
intent.
is it in the case you're citing, is finding out what Big Bob's purpose was or the corresponding party? Is that in the case?
Yeah, what was their intention in creation of the easement? Yes.
Your Honor, I don't believe that's 100% accurate. He recites them to.
He only have to be 51% active.
Well, the problem is, under Mr. Kraken's theory, the easement means whatever he says it means. And he created the deed that has the language that must be complied with. And all it says is 25-foot ingress, egress. It doesn't say so
Does
that
it
I can.
describe it?
Yes. And
Well,
it
so
doesn't,
it doesn't only say 25-foot ingress, egress, it describes it.
well, Your Honor, it does say 25-foot wide ingress, egress located at the, I'm gonna read the whole paragraph. But it states it, but the point, he talks about
It
intent.
gives a deed description of the easement.
But the intent of the easement, Your Honor, is, the intent of the easement is ingress, egress. And what Lakeside has done is honored the ingress, egress. And we believe Lakeside has complied with the letter of the law in honoring the ingress, egress. That's the point. And that's,
Well, I understand completely your argument. I'll be shocked if someone cannot reserve an easement with particular meets and bounds description that goes in there. It goes in and serving estate or the one that goes across, I don't get serving estate is the correct term, but the fee that is subject to this easement can come in and move that easement somewhere else at their discretion and not have it where the reservation is. And that might very well be the law. You says it's the law. If it is, I'll comply with it, but
As I say, it can be done in the minority of jurisdictions, including Kentucky, but it's a hill to climb for them to say that it doesn't detrimentally affect the purpose of the creation of the easement. And you've got.
You agree that the law says that it has to be proved that it doesn't detrimentally affect the purpose of the easement?
but the.
Yes or no? Do you agree with that?
Purpose is defined by the deed.
The answer is yes. He won't say.
Purpose is defined by the, not by Commissioner
Well,
Kraken's.
the purpose doesn't have, so you say that in order for this easement to be completely immobile, that they'd have to state in the deed document itself what the purpose of it is.
Correct. And that
Have
is.
you ever seen a deed that has done that?
Believe, yes, because there's, well, say you had a property owner who owns a house in the back. There's a deed that says, I want to maintain my driveway for my home.
Well, I mean, you're saying if the end of the driveway was the house, you could move the driveway anywhere you wanted as long as the end and the beginning and the end was at the same place.
As long as the standard under the law is as long as the other party is not materially inconvenienced. That's the standard.
So that's a factual question, isn't it?
That's correct, Ron. Here, I think the answer has to be no, because before Lakeside did work, it was an impassable hillside, only traversable 5 foot. Now we have a roadway that can be driven from the one side of the property to the other. There's no way that is material inconvenience. Actually, that is an improvement to the property.
Your Honor, he's talking about an improvement to the easement, which doesn't concern the purpose or the intent of the easement. Yeah, they've spent money. They've leveled this big RV park out down above Grider Hill. They got down there, and here's the rest of the story. They got down there and they started moving dirt and tearing this easement out and never called Bob McCracken, never said a word to it. We had to file a lawsuit to put a stop to it. Had no consideration whatsoever of my client. None. That's long before Mr. Wingfield got in this case. Now, they had to level this out anyway.
Anything like that, would you, Mr.?
But it's
I think
Lakeside's property to do with it as it wishes. If he wished to, if McCracken wanted to develop a property, he could have. He sold it. It fronts the roadway to the marina. It's valuable commercial real estate. Lakeside used that opportunity to develop a commercial property. That's their right as the property owner. And they have acknowledged and honored the easement through the construction.
They can do what they want to with it as long as they leave our easement alone, Your Honor.
Okay. Thank y'all very much. And take a look at it, take a look at the arguments, the case, or anything else you want to say?
If you're going to take an advisement, council filed his response yesterday, I'm fine with the time. I think I had a chance to respond.
You want to
today.
reply?
I'd like just to put the final word in the record. Could I have 2 weeks because next week, spring.
I'll give you 14 days.
Okay.
And so if he's going to do that, give me 7. I don't want a week. I just want 7 days.
I don't think he gets right to reply. I mean, the protocol is.
Well, whatever, that's fine.
I think under the rules, I get the last word.
Let him have it. He.
Thank you, Your Honor. I'll tender it. Should I contact you when it's filed or simply to get the?
I'll file it, send it to us.
All right, thank you.
Thank you very much. Okay. Stockton versus Tompkins. Stockton versus Tompkins.
Talk to people about the issue.
Okay.
But what? Take on sheets. They might have to rough after that. Your Honor, my client, Miss Tompkins, called Monday and called again yesterday. Paul Tompkins is her grandfather, and they're all just so close. He's not going to live many more days. He's in Lexington. He's had a stroke. Yes. So she's not here. I spoke to Mr. Garman. I think this is on for review only, but that's why Miss Tompkins is not present. They're all.
Okay, well, catch me up on what we need to review.
Judge, we had come to court on their motion for exceptions, I think in the end of July. Your Honor had issued a verbal order from the bench, per my memory, to send it back to Mr. Soam for additional findings.
The wishes of the children and the interaction in relationship stuff.
Yes, Your Honor. Our position was at the time that it had already been sent back once prior to that. He had already done that. But we're essentially, Norb had called me after I sent an update to opposing counsel and him asking for an update on it since it'd been several months. He called me and said that he went back and reviewed the docket sheet. There was nothing written on there about what he needed to edit. Essentially, we're just here trying to get clarity on what we need to do going forward to get moving.
Well, somebody should have created an order and submitted it to us. I had some interlineations that I had made when I looked at it, and it talked about the DRC's failure to consider KRS 43272A, the wishes of the child, of the children, right? Subsection C, interaction in a relationship with children with their parents. Was there anything other than that, Mr. Cross?
Ali, Your Honor, that's been, as Mr. Garman appropriately said, that's been long ago. And I know the court wanted some things specifically set forward, but as far as an itemization, I cannot independently recall.
Well, I guess we can pull the docket down. We pull the tape down and take a look at it in an order, within an order.
Your Honor, there's one other item I want to bring up, and Mr. Garman has.
I guess the commissioner could have done that too, but didn't.
Mr. Garman's consented for us to address this if there was not an agreement. There's been the parenting time of Mr. Garman's client involves in part kids going down and staying with his aunt. And there's been an issue, and we assert the boys are coming back and there's an apparent bed bug infestation. And we don't want them back there until this is remedied in an appropriate manner. And when I mean an appropriate manner, there's things you have to do to treat to avoid this. And Mr. Garman has said his clients are not in agreement to that. It's not her parenting time anyway. So
Judge,
we don't plan on sending them back if they're going to go to her house.
Judge, as with most things in this case, there's not an agreement on as to the facts. My client says that there's been no infestation there. There's been nobody else bitten except for the 2 children.
Somebody's talking that's keying the mic. You cannot talk in the courtroom.
Sorry, Judge. There's been nobody else bitten except for the two children, none of the other residents of the house, another child stays there. There's been no issues. So his position is that the issues are coming from the other side.
Your Honor, as an expert on the hospitality industry, bed bugs are confined to one bed. And that's the one they're sleeping. They didn't bring them in. It's just one situation. We just don't think they ought to have to go back there. We've got photographs. I think it's,
What proof do you have of bed bugs?
well, we have photographs, Your Honor, which I can submit those to the court. And we also have the medical report. We just got this stuff like 2 or 3 days ago.
Okay. Rather than deny the bed bugs, have you looked at the photos?
No, he hasn't brought it to me.
I called him yesterday. We just got
Well,
this
y'all
stuff.
need to go back there and exchange because who, is it this gentleman's parents or something with
His
the bed?
aunt.
Aunt where the bed bugs? You don't know whether there's bed bugs there or not.
They showed up with bites on them coming to my house. This has been the second time they showed up with them.
Yeah.
The first time we don't have animals, we don't have anything.
Well, you don't know where the bites came from.
Nobody does know. The first
Well, I
time,
know. I don't want to go into testimony.
the doctor said.
I don't want to go into anything else. We both agree that they had bed bug bites.
No.
I thought you said they showed up at your house with bed.
They had bites. They didn't, the doctor didn't determine whether it was bed bugs. She actually said they were fleas the first time.
It's not what they're saying in there, what we've seen, Your Honor. I'll pull it up here if I can.
We all go back and decide whether we got fleas or bed bugs. This is.
We don't know animals.
Thank you so much.
Your Honor, he seems to have a lack of understanding, but don't come from animals. They just,
I'm talking about from the flea bites. They said-
Well, there's a
that was what
disagreement.
it was.
Wait. They're either flea bites or bed bugs. So neither one of them are good. So
right.
go back there and show them what you got about the bed bugs, that the bed bugs bite. I missed that class in law school where we determined about bed bugs and fleas and things, but I'm sure you were there. You there? Had that, they didn't have that. Okay. England versus England. Okay, what we got?
Judge, this was my motion to modify the parties' original agreement to have my client designated as the primary residential custodian because their minor child, they have one minor child that's still living
Yeah.
in the home with my client. He was originally ordered to be in the home.
You've
With Miss
lost me
Watts.
somewhere.
I'm sorry.
Let's,
They had 3 children together. All of them have reached the age of majority, but the youngest child. The youngest child was originally residing with Miss Clip, Miss White's client, then came to reside with my client.
by
toward-
agreement between the parties?
Yes,
Yes.
they just didn't do
Now
anything
what
in
do you wanna
writing.
do?
Well, we wanted to modify to have that shifted over to him being designated as the residential custodian.
From her client to your client?
Yes,
Because the child's actually living there.
yes, it has for a
Okay,
number of
what's
years
your
now.
position?
Our position on that is it is fine with
Move
the,
over here.
Oh, apologize, Your Honor. Anna White for Christie England, now Clip. Our position is that the child did go live with dad. The parties agreed. Mom does not mind if they change it, but she wants to make sure she still has some visitation, timeshare.
You do an order that will satisfy the visitation situation.
Well, that's the issue, judges. We've got a child that's 15, soon to be 16. So what we had proposed to them was to do a come and go with the child.
I'd rather have set visitation so the child doesn't get to be the boss in the
Yes, Your Honor.
situation. And that will resolve conflict as to whether or not your client's trying to influence the child and that sort of thing. So go back and try to reach an agreement on that. We'll come out, and put it on the record. And if the child doesn't want to comply, the child will have to come to court itself and give good reasons why it shouldn't comply.
And that's, we've had those discussions, Judge, and I think that's frankly where we are, given some of the circumstances of why
Well,
the
then-
child
then-
doesn't want to go.
Then I'll need to know about that at some juncture, but we'll create the order first and then we'll see where that leads us.
And
Okay?
Judge, we would prefer not to force the child to testify. This kid's been torn back and forth a lot.
Let me tell you, I can just put the order in, and if the child doesn't want to comply and you want the child to comply, then the child will have to testify. If the child doesn't want to comply and you're ready to accept that or acquiesce to that, then she won't have, the child won't have to testify.
All right.
Okay?
Yes,
I
sir.
won't make a child testify unless you want to try to enforce your order.
All right,
Okay?
fair enough.
Okay, thank you. If y'all go back and work on that someplace. Mitchell versus Mitchell.
You got my email.
Okay.
Mr. Cross is in this one as well.
Can we retrieve Mr. Cross back there? Can y'all get Mr. Z back in there some? Oh. Okay, we just call this case Mitchell versus Mitchell. What we got here? It says for review.
Your Honor, it's our motion for review. As the court will recall, this is the case that through their second attorney now, that the respondents have done a stellar job of avoiding my client having any visitation or parenting time whatsoever now for several years. There was a strong history of violence. The folks went to an evaluation. I think the record.
Okay, violence by whom against whom?
I'm sorry.
By my client against, it's stipulated there was domestic violence.
Okay.
Within the marriage about 5 years ago.
Okay.
Yeah. And the court wanted them to go to a psychologist, if you recall now. And we've recently done a 4-hour domestic violence program. We've had anger management in the past. We're willing, Your Honor, to do whatever the court requests us to do, but we'd like to.
The children are 7 and 8, and you had made note, you reviewed the file the last time we were in court.
You need to speak up a little bit.
Oh, I'm sorry. You had reviewed the file the last time we were in court in December on how drastic the domestic violence
Yeah.
was. And the parties went to community-based intervention. The therapist recommendation, of course, the court had a copy, were actually for him to do a domestic violence perpetrator program, or a batterers intervention program. And that's much more extensive than just a 4-hour domestic violence class.
Oh, we didn't have any.
You didn't get, I have copies of those here. I apologize, I may have.
They are in the court record.
We don't get things that are filed in the court.
That's where we messed up. We didn't see it.
Okay. And not to jump out of my turn, but the issue with
When you
this,
file anything in the court record, you need to copy it to the circuit judge too, okay?
yes, we certainly will do that. And I'm not sure if we filed that, but I'll certainly make sure we do
Well, it's
that.
in the court record.
It is,
You didn't
okay.
get it.
You didn't get, it, okay.
I think they did.
I think the community-based interventions may have seen, I'm not 100% sure how that works.
What do you want to do? Let's get down.
Oh,
to
yes,
cut
I
to the
will. Okay,
chase.
so the issue with this is,
What do
I
you
will-
want to, what do you want to do?
what do I want to do? We would like.
Other than him just go away and never hear of it?
No, and I get it. I get it. So this therapist says that she's not qualified to make a recommendation.
What do you want to do?
We would like him to do an actual batterers intervention program and,
Where's one of those located?
we had thought that they could do this at the community-based intervention. She's saying that's not available now.
Look,
Mhm.
when y'all need to quieten down back there. You cannot talk in here without it keying the microphones. Thank you. Okay, now, if you come here and ask for relief,
Mhm.
you need to tell me what relief you want. Now, you thinking somebody might have something else. I mean, Mr. Cross and his client have expressed an opinion, and any kind of domestic violence is awful and horrible. It's not acceptable. But if there is a certain program that you want to suggest, then suggest it to them, and he can consult with his client to see if he's willing to go through it, and then we can get a plan
Mhm.
to try to get some visitation. Other than that, we're spinning our wheels.
Exactly. Well, we would ask that he go along with the therapist recommendation, which is this batterers intervention program, and that's.
Where is
can-
that located?
They are throughout the state. I do know that.
I've
when I
never
had-
heard of one of them. I don't know.
I think I mean, it's a pretty intense thing. It's about a 13-week, it's a pretty intensive thing. I know the last time we were here, we called a couple different places and given some options to them. So.
How long ago was this domestic violence?
8 years. 9.
Yeah. Have you done any research to see if he has any criminal record or anything since then?
Yes, he's had,
Okay, tell me what it is.
it was as recent as 2 years ago.
And what was that?
I believe it was,
2 DUI.
yeah, he's driving under the influence. He's had a pretty extensive past. That was another thing that the therapist also recommended for him to do something
Okay.
to assist in
can
his
you
sobriety.
suggest- Can y'all step out maybe and call one of these agencies to see if they've got a program and what they'll suggest and how quickly you can get into it?
Yeah, yes.
Could you do that with a
Be
Mr.?
happy to, Your Honor.
Yeah.
Report back to the court here in a moment.
And-
Yeah, that'll be good.
Okay. we can do
We'll make sure that everybody tries to have a level of comfort with that, okay? Okay, thank y'all very much.
Try to find somebody on the phone and I'll-
Baker versus Baker.
I believe Ms. Capps is on this case as well. She may be.
What are they doing back there trying to decide what? Well, maybe let's go to Haddock. We'll come back to that. Okay, let's go to Haddock's versus Harden.
Your Honor, I think that's my motion primarily to approve an attorney's fee for, this was a hybrid action. It was a foreclosure, but also an indivisibility case. I've asked for a fee of 1/2 of what the schedule is.
Let's see. I don't see that motion when you. Oh, there it is, right there. $1,640.
I'll take half that.
I was fixing to give you $1,640.
I don't want that. No, if the place just only brought 17,000, that's too high.
I don't see an order in here.
Well, I'll get you an order.
I mean, you'd be entitled to
Well,
that.
I know, but it's a hybrid. because
Okay,
mine's a
all right,
party and
all right.
they're just different things. So I'm
Okay.
satisfied. I'll get you an order, Chair.
Sheila Sells versus as administrators versus Jamie Lynch and others. Okay, what do we have here?
Good afternoon, Judge.
Hello.
This is a motion to sell real estate in a mobile home. This is Miss Sales. She's my client. And she would like to sell the property to pay indebtedness. We'd like to have it referred to the master commissioner also for sale.
Is it just the mobile home or is there land involved?
Both.
There are insufficient assets to pay the debts of the estate.
Yes, you agree
There's
with
been
me?
the objection filed.
No objections been filed. 2 answers have been filed, but not objection to the sale. One by City of Albany, the other by Cabinet or Department for Medicaid Services.
And they have priority for it.
Yes. Well, we can discuss priority after the sale, of course.
Well, I'm asking you now.
Yes. They have priority.
Okay, that's what I thought. And that's it. I don't see a signature line for the judge on there. Maybe I'm overlooking.
Oh, it's got Norbert on there instead of you. I'll correct that.
We're all quite frequently confused.
I won't make any other comments. Yeah, I'll be back. I'll correct.
Okay, and now also you need to pay your money, don't you, for, you got the check here. Now that the clerks are, Mr. Staten is very observant as whether I collect these or not, you know, and if I don't collect them.
Right, I'll be back.
Not
with
pleased, am I right? Okay, so if you bring that back up here.
I will, we'll change that. Megan, do you have that Jennifer Stockton case to submit? It's agreed divorce. I just want to make sure it's in the stack.
Yeah, it was.
Wilson versus Thrasher. How are you doing?
Doing great, Judge. How are you?
I'm blessed. Thank you very much. Okay, what do we have here?
Judge, this is my motion. Essentially, we just are looking for a date either in front of the court or in front of Norb, so we can file temporary custody motions to be heard on this. There's no motion.
Give me some background.
Judge, these parties have two children. Can't remember the exact ages at the
Are
moment.
you Mr. Thrasher? Where is Michael Wilson?
Judge, he's not here because I just filed a motion for a court date.
Oh, okay.
I
Well,
told
we
him.
might, I always like to have the parties here in case we might be able to resolve things, you know.
Judge, that was my hope, because I think things have turned kind of increasingly more volatile with the parties. And we do need some sort of temporary agreement, to get us through till we make it to a hearing.
I don't know anything about volatility or anything about situations.
Judge, all I can say is that they haven't filed any motions, and the only motion for your honors.
I got you. I got you, you know. I take things up every day without motions if there's a exigent circumstance or need to do anything. Do you think that there's volatility here that they need to talk?
I mean, I certainly want to get a resolution.
Well, that's a start.
Yeah.
Do you want to get a resolution also?
Absolutely.
Well, now we've made progress already here. Okay. So tell me about the volatility, things going on here.
Judge, Ms. Thrasher feels that there are some verbal abuse issues going on. There's some anger issues. He's currently been suspended from the medical center out here in Albany where he is a physician, pending an anger management evaluation.
Didn't recognize the name, but I know who he is now.
We've kind of got some, school records that have came in this morning showing that the boys are kind of going down with their
How many
grades.
children are
There are two, Judge.
they male or female?
They're
Two
both
boys.
boys.
How old are they?
8, 12, 7, 13. 7 and
7
13.
and 13. Okay. And how has paternity been acknowledged by Dr. Wilson? Are there documents where he's acknowledged paternity? Has it ever been said before?
There's never been anything other than the petition we acknowledge paternity.
You did.
There's been, yes, Your Honor.
You did in the response here.
We were the ones that filed the petition, but yes,
So you, in it, you acknowledge the fact that he is the biological father of those two children. Well, you know, that's something that needs to be established at some
I
point.
agree, and I had that discussion with him, and my understanding is there's no question as to.
Well, I didn't say there was, you know, we just have to get it down on paper, as they say. And, I mean, I would like for y'all to step back in the room back there and see if you could work some visitation out. And you've got some allegations that there were, some threats or violence or something like that?
Yes, Judge, yes.
Okay. Well, I would suggest that we schedule a hearing very quickly. If y'all could go back, are there trusted family members where she would feel comfortable until we do something else? And I'm not saying I'm going to say anything today without your client being here and having an opportunity. But if you get a hold of him, if she has some reservations, I usually find in these situations that that caution is a good thing. And if she has these things, if he'll show some good faith in recognizing that she has these reservations, to allay those reservations until, and without making any admissions, until we can schedule a hearing. And it sounds like the sort of thing that I probably need to hear myself, rather than the commissioner, you know, so we don't have to go through the laborious process of getting recommendations and getting that sort of thing. There's not even marital property.
No.
Because they weren't married.
Correct.
So there might be other, there might be, if I know things, there's usually some financial entanglements that you have to deal with anyway, even if there's not marital property. But then we got the matter of support and those sort of things. So there'll be a need to exchange information on that predicated on who's got it. Now, I don't do family law all the time. Do the same presumptions of 50-50 time go to people that are parents that are not married as they do that are married?
Yeah, I don't believe the statute differentiates.
I don't know. I just,
I've never seen any difference.
does it differentiate?
No.
Okay. Well, we got some big time practitioners here that I'll take a vote on until I know better, you know, so, I don't know. But, if y'all will step back there and see if there's anything, and then we'll come back and get the calendars ready, and we'll need to, take a look at this, and get a time. The hearing might be held in Burkesville because of the availability of the court facilities here. That's not too far over there, you know. Yeah. So if y'all will take a look at that and report back out to me here in a minute or two, okay? Thank y'all very much. Okay, now let's go back and see if there's a, okay, got to add that one to a thing. What do we have? Okay, Stearns versus Stearns. Stearns versus Stearns.
Good afternoon, Your Honor.
Mr. Speaker, how are you today?
Good, sir. How are you?
Blessed, thank you, I'm blessed. Okay, what do we have here?
Judge, I think the Child Support Office filed a motion regarding an arrearage amount that they were seeking to collect. Mr. Stearns has since paid that, so they withdrew their motion. I have a motion, I just recently got in the case. I have a motion to establish an arrearage amount and a motion regarding some real property. Ms. Perigin and I have talked since I filed my motion. I was not aware that she had not received from previous counsel copies of receipts and invoices. So I am handing her today all of those copies and records.
Which she really appreciates.
Yeah,
Sure.
she really does.
So much.
But I'm also asking the court to allow us to pass this for 60 days to see.
I'll always agree to that.
If we can resolve it.
How about 90 days?
Well, that's fine.
Okay, let's go into the real estate situation for a second, then I'll come back to this, okay? What's the real estate
The
situation?
real estate issue is pursuant to a mediation agreement. He was to deed some land to his daughter, who just
His
turned.
biological daughter, your biological. Yeah, he was to do.
Yeah, some land to her. She just turned 18. He put the land in both their names,
Both whose names?
he and the daughter.
So he retained an interest in.
He did
Solely because she was a minor.
because she was a
Now,
minor.
she's of age. now.
She's
Just
getting,
recently.
What's your client's position?
He's agreeable to,
Quit claim deed?
yes, that's fine.
That's okay, you prepare a quick.
well, the
Yeah.
only issue is, and I'm not familiar with what happened at mediation yet on this issue. I'm asking to pass that motion too. The only issue is whether or not the land is inhabitable and is what they agreed to or not. But I think we can resolve that. I'm just asking to pass that.
What do you mean inhabitable? You think it might have been?
Well, my client believes it's on a hillside. You can never do anything with it. You can't even get
It's
water.
been the same land all the time though, hasn't it?
Yeah, but there was no agreement on the specific land he was to give her. He was just to give her 3 acres.
Well, then there was no agreement.
Agreed, Judge.
Yeah.
That may be true, but I haven't looked at it.
The
That's
only
all I'm asking.
agreements when there comes a meeting of minds, you know.
I understand.
I always find that people want to keep the flat land and get the hill, and that's what my people all got back in the 1800s. So yeah, I got, you know.
You didn't get any flat land?
We get no flat land, maybe a creek where they consider flat, you know.
Well, as Donnie Ray Stevens says, on the banks of the Carver.
Yeah.
What you got?
Yeah, I got on the banks of, creek up there somewhere, Goose Creek, which is very valuable now, but wasn't when we got it, so. Okay, well, y'all wanna hold in abeyance. How far back are these medical bills and
They're
stuff?
back to 2010.
Well,
Let me say this, there were previous motions filed, there was agreements to pass. I think we can.
how much money would you take to like?
The total amount that I have.
Well, I didn't ask you how much, I said, how much money would you take?
Well, I don't know. The amount's 25,000. I don't know how much we take.
Then they can't make you offer on it.
Not today.
Okay, well, work through it. 25,000 is a lot of money to go back 14 years to try to collect. Is it, you know?
I agree. That's all.
I mean, it's gonna cost her more if you go through those records than that.
Judge, you know, I'm cheaper than that.
I know you are, but at
I
$100
don't know if
an
I am
hour,
though.
we can get you on the record to set a fee for your client, and that way it protect you. I'm sure you'd like that when you can limit his fee that you're not charging.
I advise you.
Yeah, you might. Just take a fifth on that, right? Okay. Well, this is a serious matter because you're talking about, it's hard to defend against something from 2014 in all fairness to this gentleman, you know, and if he's made his child support arrearages up, and let council take a look at that. And then to take a look to see if there is a meeting of the minds. I mean, if there's not, 3 acres, is kind of like that easement. I guess you could move what we talked about earlier. You kind of move it around a little bit. You know?
Well, this is a little illustration of why you should always have child support paid for the child support office.
No doubt
They didn't
about
start that till about 2 years ago.
No doubt about it.
And so
Yeah.
that's.
And any claims to medicals and that sort of thing and offsets. But you know, we're not gonna have any child support in the future with this 50-50 yet. This 50-50 presumption, everybody's gonna get 50% custody, nobody's gonna be paying any child support. So then we'll have to start talking about maintenance, and I guess, in the future, I don't know. But you know, we have to talk about maintenance. Ms. Capps has advised me from the peanut gallery here. I hope she knows more about it. Okay, thank y'all very
Thank you,
much.
Coach.
Yeah, okay. Another add on here. Young versus Young.
Your Honor, I think that's Mr. Garman. We'll be getting some of that.
Is this your,
That's the correction, Judge.
the Sands Norb?
Right, you could sign it either way.
Yeah. Okay, thank you.
Thank you.
Here you go, young lady. Here you go. Young versus Young.
Judge, this is a divorce that, I filed back, I don't know, 11 months ago or so, sometime last spring. Miss White's, client at the time, and I believe still to be, is in federal prison. My client is just desirous. This is a case where they've been separated for a long time. There's not going to be a lot of issues as far as what to divide. But we do need to have some kind of a hearing where we can put proof on the record and get him divorced.
Yes, I've got to try to relocate her. I've not had any luck in communication with her, but if we get a date certain, I can attempt to do that again.
Well, is there any property to be divided?
Not according to my client.
No, I don't.
Okay,
sure there's
well,
not.
You know. So what's she in the federal penitentiary?
I think it's drug related, pretty serious drug charges.
I'd like to hear what kind they are. I don't know the feds are doing any drug charges, you know what, but that's okay. That's
It was
okay. I don't really care.
Big volumes of drugs.
I don't care. And obviously your client's not gonna claim you that as marital property, is that what you're
I
saying?
don't believe so. It's not made me aware of such a claim.
All right. Okay, well, I would think that we could, you're not comfortable then, having a hearing on it. I mean, I can enter a divorce without resolving the property issues and hold them in abeyance if your client doesn't feel like that, he's put at risk because he claims there isn't any marital property, and that would give Ms. Potts some opportunity to contact her client to see if there is any marital property, and we could finish it up like that. You know, I could bifurcate.
I'm sure there's not. It's just the children, and she can't make any claim to them at this point because she's
Yeah,
got a
right.
significant sentence.
Well, is there order about the children in place, or is she just not anywhere where she can say anything about it?
No, Your
Does
Honor,
he
he's
have the
just-
children?
Yeah, he's
How
just
many
had-
children are?
There's 3 children. He's just had the children because it's not
Yeah,
there.
well, I tell you what, let's do. Would he like to go ahead and get divorced?
Yes, Your Honor.
Well, let's bifurcate the thing, and you send me a divorce order, we'll divorce him and hold in abeyance, and reschedule any kind of, there might need to be little testimony taken, really.
I couldn't
You know,
imagine
just
there'd be
a
much.
jurisdictional testimony, and then the fact, and then you might get down to the children, and I don't know what to do about that.
I don't either, but I'm fine with doing the bifurcated, and
Okay.
I'll let her know that.
Well-
She won't respond to me at this time.
Yeah.
Judge, I'll submit a deposition with only the
Factual.
jurisdictional proof and a bifurcated or
You-
tendered. an
And you
order
won't
of that.
object to that?
I'm not gonna fit.
Okay, thank you very much. And then y'all can reschedule. You want me to, why don't we try to take a look at it on April 11th, see where you are on that, okay? Okay, thank y'all.
Thank you.
What's next? Okay, let's go back through the call here. Does anybody that's previously been up here have anything that they want to come back up about?
Perhaps Mr. Garman and I need to about the bed bug issue,
The bed bug issue,
or fleas, or whichever it might be. Your Honor, I have forwarded Mr. Garman a medical report and photographs and whatever it is, it's, I go with what doctors say. I don't diagnose. They say it appears to be bed bugs. We just want to be.
What do y'all want to do about it?
Judge, I mean, my client says that they've gone up and down the house on their side, looked at everything. There's no issues. They've
That's
replaced
his aunt's
beds. and
house,
done-
who's it?
Yeah, he says they've replaced beds and done all these different things. His position is that. it comes
How long's
from
it
the
been
mom's side.
since there been any bites, Mr. Cross?
Last time they were there.
Well, I don't know. That's
I'm
like when
sorry.
mother died.
This-
I don't know
this
what they
past-
do.
Past weekend, was it the past weekend or the weekend before?
Well, so let me tell you, when's the next time they're scheduled to be there?
Right.
Right, well, I'm gonna let them go ahead and you monitor it very closely. And if you give me any proof that, and they need to take pictures of the children before they go over there to show that they're not getting bit over at that house. You know, and then when the children leave, they should be taking pictures. Now, I'm talking about modest pictures. I want you to take that into consideration, you know,
That's fine.
make sure you.
They're big old boys, it'll be all right.
Yeah, okay.
They're about old enough to start driving over there.
Yeah, well, they might fight back on that a little bit,
They're,
but,
they're acquainted, they can handle it.
okay, thank y'all very
Thank you.
much, yeah.
I think they know. That day, so.
What is it? Okay, Baker versus Baker.
Judge, we've finally come to an agreement and signed, my client and I have signed the paperwork and forwarded it to Mr. Wilkerson.
Received it yesterday evening, was finally able to review it.
Well,
And so.
blessings be on both your houses.
Yes, so, and so we
Yeah.
did have time to withdraw the motion, need to meet with the client.
Well, that's
paperwork.
wonderful.
And I would say that we could both submit a joint motion to have this thing on.
That's
the
great,
decree.
wonderful.
Yeah.
Made my day.
Okay, all right, thank you, Judge.
Just send me whatever you want to do.
Okay, is there anybody else ready to come up?
Judge, on the England, nail clip versus England, Ms. White's and I are going to submit an agreed order to the court.
That'd be good. Okay, is there anybody else? We're on a roll.
We'll have to read the Mitchell case. We're trying to make a phone call on that, so I'm waiting on this.
Okay. Is there anybody else that's still out there? Okay, well, let's go to the criminal docket, and anybody that has a civil case can intervene when they get their agreements. Okay. Are we at the out of custody docket now with Colton Abston? Would that be a good place to start? Colton Abston. Commonwealth versus Colton Abston, 24 CR 001. Are you Colton Abston?
Yes, Your Honor.
You born in 1998?
Yes.
Last four digits of social security number 4431. You're here on a pretrial conference. What does the Commonwealth have to say?
Yes, Your Honor, we need another negotiation day.
Negotiation date in Burkesville by agreement of parties on April the 5th at 1 p.m. And you'll be back here on April the 11th for your next court appearance. Both of those are conditions of your bond. Do you understand that? Okay, thank you very much.
Thank you, Your Honor.
Yeah. Troy Albertson.
Judge, he is a probation and parole absconder and has a active warrant.
Okay. The Commonwealth aware of that? I'm going to put an NCIC.
Yes, sir.
Okay, John Brown. I'll be John Brown.
I was informed that the warrant, out of warrant position. And we had filed a motion to revoke bond because his ankle monitor had died and it's never been recharged or even turned in, so.
You want to testify or I didn't know you?
Not this time, Judge. I don't know where John is
Well,
either.
we'll find John for you, so
Thank you,
for
Judge.
your convenience, so you'll be able to call him. We'll have Chase with that. Warrant issue, please. FTA, Ferdinand Gerger. Who's here this morning?
He may be outside. I seen him.
Yeah, it's Ferdinand.
Yeah, I know.
It'd be good if you met with probation parole officer, if that's the case. Get off of that, an auspicious start by not being here to go on.
Judge, he was here this morning.
I can try to get a hold of him. If you just want to put him back on probation, I can try to get a hold of him.
I'm gonna give Ferdinand a break here, cause he might have got lost in the shuffle.
And Judge, I think part of his issue, especially was some transportation, not making excuses for it.
Well, that's okay. You go ahead and we're gonna sign an order putting him on probation and not sending him to jail because he couldn't qualify for drug court.
And if I can't get a hold of him, I'll
Put
do
him-
the proper.
Yeah, if you can't get a hold of him, issue a warrant for him and we can let him out quick after you get a hold of him, you know. Michael Likens, active warrant.
Your Honor, I believe we're in one accord now on Mr. Lyons.
Well, I'm gonna tell you why I wouldn't let you say anything earlier, because he wasn't in front of me.
Mhm.
You know, and then now you're here, and does Commonwealth have some announcement to make concerning Michael Likens?
Yes, Mr. Stockton is in agreement to let a criminal summons be issued.
Okay,
for him
that's
instead of
when
a-
I'll accept an agreed order on that.
We'll do that
And summons him back on the 5th.
Your Honor, I'd rather just have him here. He's not been arraigned, so we'll have to have. him
Well,
on.
I know, but we do things on information quite frequently and everything. If you want to get him into the process, I would suggest that he come back on the 5th for negotiation. And then when he comes for arraignment on the 11th, you know something about it.
He won't have his medication routine completed until the 6th, if that's soon. He won't have it done.
Okay, well, he can be here on the 11th and I'll schedule him other days and withdraw the warrant.
Now, Your Honor, I think one of the purposes of doing a summons was if he was having difficulty traveling to allow him to appear by Zoom. And if we,
Well, here's the thing about it, is we're a long way from except we don't have any medical records here. Is that correct?
I think Mr., I think
I
that there
want a
has
full
been
set of
some-
medical records about him zooming
That's
in.
fine.
I don't want to start getting people zooming in because they claim they're sick. I hope he's
they're
not
available,
sick.
Your Honor. We furnished Mr. Stockton his
Just
part.
to your satisfaction, and then by agreed order, he can appear by Zoom.
Okay.
But I want him here, if at all possible.
That's fine.
Okay. Brian Markham. Commonwealth versus Brian Markham, 23 CR 0050. Are you Brian Markham?
Second.
Born in 1982.
Yes, sir.
Last four digits, social security number 8609. Okay,
Yes, sir.
what do we have here?
Your Honor, I believe that it was set for a suppression hearing, but there was no motion for suppression filed, so we're just ready for a trial date.
Okay, well, Judge, we can do that. The reason there was no motion, I think the hearing we had this morning, we anticipate going a little bit long. We had talked about doing a number of suppression motions on the 411 docket, this being one of them, but we can set a trial date as well.
I didn't understand what you just said. You still have suppression motions that you're gonna have heard in this case?
Yes, Judge.
Why weren't they filed today?
I had spoke with the Commonwealth. There were 3 that were supposed to be heard today. In addition to Ms. Burchett's very long revocation hearing.
Well, nobody could have anticipated you could have stretched that long. But we couldn't have anticipated that, nor could you might have anticipated,
I
but no
did.
one else could have anticipated. But now, when you suggest that we, considering the length of recent hearings, I'd say we better schedule your suppression motions on days other than rule day.
And Judge, I have no objection to that.
Yeah, okay. You
Get
have,
a little
are you
long-winded
gonna,
sometimes.
you gonna do it, or who's gonna do it? Mr. Stockton gonna do it? What kind of suppression motions are you talking about?
Judge on fire proffer,
On what?
Sheriff Markham, on this case, Sheriff Markham went to search Mr. Markham's property, and this was upon an anonymous tip, so it will begin the suppression at that point.
Is it a warrantless search?
Yes, Judge. And Judge, if Sheriff Markham's available, we don't, Sheriff's available, we can do it today. We're here.
Well, I don't think the Commonwealth's been prepared. You gotta
We have
file a
one
motion.
second.
There's not been a motion filed, and we're not gonna. do it
Absolutely.
today. Y'all get together with Mr. Stockton and see if we can come up with a date that will give him sufficient time to prepare his witnesses and call other witnesses if he has.
And
We've got his calendar.
Okay. Well, I know, but you got his calendar, but you don't know when he'll be prepared for it. First place, he hadn't received the motion. So you serve the motion, and then after the motion is, y'all can contact me directly to get a time that's convenient for the suppression motion, okay?
Yes, Judge.
Okay, thank you. And then we'll set, but at the same time, we'll set, when we have the suppression motion, before the next rule day, we can set the trial based upon what I find in the suppression motion, okay?
Yes, Your Honor.
Troy Pryor. You need to tell your client that he needs to answer your phone calls to be there at the suppression motion. You understand?
Yes, he's been in contact with me.
Okay, but I mean, I don't want us to have it and him not be there.
Absolutely.
Troy Pryor. Commonwealth versus Troy Pryor. 21 CR 0096. Are you Troy Pryor?
Yes, sir.
Was you born in 1962?
Yes, sir.
What is your social security number? 8761? Okay, we're here on a probation revocation. You step to the left here. What do y'all have on this?
And Judge, I will just say for the record, this is my first time meeting Mr. Pryor. He brought in some medical records.
I want to know what they're,
Okay, and
before you slide out of it, I want to know what we're here on. I understand you might not have time to talk to me.
Yeah, this is a motion to revoke Mr. Pryor's, probation. And from what I've been handed, it appears that he has additional charges for possible DUI in February of this year and for possession of methamphetamine and marijuana. They are charges, yeah.
Do you have any information about this?
Citation, he was charged with possession of controlled substance, first degree meth, possession of marijuana, possession of an open container in a open alcohol beverage in a container in motor vehicles.
Well, was he over in Cumberland County when he did that, or?
No, he was.
Well, I know there's no alcohol here in Clinton County.
He was in Clinton County. He is actually supervised by Tennessee out of, Tennessee probation and
Well,
parole.
that makes me feel better.
Me too, Judge.
I've got a copy of the citation if you'd like me to read it.
That's my
Now,
question, Judge.
they've
Are
turned
you
down
want,
supervision.
No, he's still supervised by them.
Okay, but they reported to you these violations, and they asked y'all to act on it?
Well, I actually found out from a hit, our interstate contacts office sent me a email that said, hey, this guy's got a new charges, new charges, check into it. And when I checked into it, I contacted Officer Stop, or Commonwealth Attorney Stop.
we can put into evidence the citation that we have, Your Honor.
You what?
We can put into evidence the
Yeah,
citation that was entered.
was he arrested?
He was not arrested due to medical issues.
And it's, again, just to look at the procedural posture of what looks like a case I might be getting in Cumberland or here or somewhere. I don't think he's even been arraigned on these charges yet. This alleged arrest was on February 12th.
Of course, he doesn't have to be, even criminally charged to revoke his probation for drug violations or DUI.
That's true. If we had any direct evidence, Your Honor. Now,
Well, I want him to
that's
sign,
the
and you live
position.
in Tennessee, so,
I know.
do what? You live in Tennessee. Okay, that's all I ask you. You need to not say anything else more till you talk to your lawyer, okay? Unless you want to just blurt out, I'm guilty, take me on to jail, and we can just resolve this situation without any other
I don't
formality.
think you're gonna say it.
Okay, I want him to do a sworn waiver of extradition here where he'll, agree to come back. He's come back here. I don't see any reason to put him under any bond at this particular situation. You got those waiver of extradition forms? You'll agree to come back under oath, right, without us going back and getting you? And so have you contacted the probation and parole office down there that are supervising?
I contacted them yesterday to let them know that he had the court today.
Have you talked to them?
I have not talked to him.
Well, I'd like for you to talk to him and see what their intent and whether they're willing to keep him under probation or if they're gonna violate him there. In my opinion, if they're gonna take some action against him down there, and that usually when something like this happens, they send him back, right?
I sent in a request for a progress action and they haven't responded.
Okay, well, we'll see what they do. And
That's why I raised the issue, Judge. I didn't think it was right for the
yeah,
moment.
that's right. And I don't know whether, you know, with these medical issues and stuff they're talking about, that we want him back. You know, what, I don't know what we can do with him, you know.
Judge, I'll note for the record, I've got a stack of medical records I've got to go through that I was
It'll take a
provided.
week, then.
Mr. Pennington, I don't even see a future court date in the district court case, so. You might want to.
In Tennessee.
No, it doesn't.
It's here.
Where is this?
The DUI was here?
It's not a DUI.
Cumberland County.
They had a
No,
DUI
that's-
down in Tennessee.
That's what he's on
No, it's in
supervision.
Clinton.
Yeah, it was a possession and
He's supervising Tennessee.
I thought these actions happened in Tennessee.
No, they happened here. He was coming up here, he had come into Clinton County, and that's where the new arrest happened.
Tennessee supervising a Clinton County violation.
Yes.
Yeah, 'cause it-
Coordinated reflects possession, controlled substance, possession of marijuana, possession of alcohol, the only three charges, and it has asterisks instead of court dates for the right.
Michelle, for some reason, that it was removed from the docket on February 13th. We don't go here.
There was no actions taken. Still. But there's not any evidence to leave.
Did I hear DUI somewhere a while ago? I thought I heard DUI.
I did, that's what my documents.
I could be
He
convinced.
said possible DUI. He wasn't charged with DUI, but there was a chance of a possible DUI.
I don't feel
It's a serious
comfortable right
charge.
now with the possible DUI
It's a
evidence.
serious charge, possible DUI. Do you have any need to come back to Clinton County? Where do you live? Birdtown, Pig County, it's a long road between here and there. Yeah, well, let's continue this on the docket until April the 11th, and y'all can determine whether you want him back up here on April 11th. Now, he's got something's happening in district court here that we can't figure out. So you might check with the county attorney to see why it was taken off the docket or what the deal was, okay? Did you hear what she said about it being taken off the docket here? Okay. We got another first. We had a lot of firsts here. Yeah,
You're good, sir.
yeah. Okay. Where we at now? Number 9, Robert Cornell.
No, so he doesn't see it.
No, the warrant was withdrawn and the summons was issued. Not a summons issued, but the warrant was withdrawn and a restitution warrant was given. And Mr. Stoughton said that he would dismiss this charge as soon as restitution. Or the check had already been paid.
So you want to pass it till April the 11th to see if the check is cleared or agreed or before then? Cornell. Sausage. Johnny Stevens. Commonwealth versus Johnny Stevens, 18 CR 0059. Mr. Stevens, were you born in 1977? What are the last 4 digits of your social security number?
3940.
3940. Okay, you need to make sure that gets put on there. We have on here for review, what's the deal?
Yes, we're just checking to see if he'd been making restitution. He made a payment March the 7th. And he paid $150, so the balance now is $1,016.50.
How much a month is he supposed to be paying?
Well, he didn't make a payment last month.
It's 75.
Are you behind?
No.
No, don't, if
If
he's
it was
making.
150, he did a
He's
double
doing-
payment,
yeah.
so last month and this month.
Yeah.
So he was behind when he paid the last one. Pay him on time, okay? Be on your way, Rejoice. Who's next? Kyle
Thomas.
Thomas. Commonwealth versus Kyle Thomas, 23 CR 0051. Are you Kyle Thomas?
Yes, sir.
Born in 1996.
Yes, Your Honor.
Last 4 digits, social security number 4517.
Yes, sir.
Okay, we're here on a pretrial conference.
We're needing another day. We're trying to locate a victim.
April the fifth for negotiation, and April the 11th for your next court date. Both of those are conditions of your bond.
So April 5th, you say?
April.
I'm gonna write it down jot it down. Pete, jot it down. April the 5th at Burkesville at 1 p.m. April 5th in Burkesville at 1 p.m. and back here on April the 11th at 9 a.m.
And I'll fix it. Okay.
All right. Thank you.
Albany, 9 a.m. Okay, you got it. What else you got? Commonwealth have anything else?
The one judge, I know we never did get him on, Daniel Moreland, that was from North Point, we never did make contact with him. It was on for status from, appeal from Kentucky Supreme Court. Judge, I think it was set for a status, if we could just get a negotiation and put it back on the 11th, I think, to try to get a resolution.
What's the Supremes have had this case or?
It came down, it was.
Oh, God, yeah. The split sentence case that we had direction, they set it back, you know. So, well, you need to talk to your client. What does he want to do except wants to be free?
I mean, he wants to be free, Judge, or probation. He has served, you know, the 10 years on the first part and about half of the.
Well, it was a 20-year sentence and they said we couldn't split it.
Well, it was 10 and 10 and he messed up the second 10.
It was a 20-year sentence. Is that correct?
I believe it was a 20-year served, 10 balance probably.
That's right. And the Supreme Court said we couldn't do that. So it was a 20-year sentence. So they sent us back down here for sentence. And has he been incarcerated ever since then?
He has been, Judge.
So I don't guess a new pre-sentence investigation report would be necessary. He's been incarcerated. And what he's coming back down here is for sentencing. So by April, let's schedule him for April 11th and have him transported here, okay?
Absolutely, Judge.
And here's what I want. I want the Commonwealth to brief what the Commonwealth's position on that, and I want you to brief it, what your position on it, and saying set him free is not enough. I want some like case law or something, because they reported this case, didn't they? I think it's a reported case, but it predates me, you know. It predates everybody except Mr. Hunter. Doesn't it predates everybody but you?
Well, wasn't they? Yes, it was 2008.
I wasn't here at 2008.
It's a 2008. 2008.
That long been stopping.
Yeah, okay. Y'all can do that. It is a reported case, so we can say. And if you tell me what the case says, that'll be part of your brief. You know, I have a hard copy. Okay, is there any other criminal matter outstanding?
Your Honor, we was to visit Angela Wallace. Guys, name what's happening?
We're just. She hadn't been served with her diamond work here until after she was picked up in Miami. When she received the blanket service, then she was served about, she'd been released in 60-day notice. Technically wasn't under any law.
So we let her go.
Right.
But I believe from what I was talking about, the pretrial officer, Wayne County released her bond, put $5,000 cash for her, so I believe they'll export that.
Well, so what is your bond here going to? It's your going to be on.
She's out.
Okay, she's.
Because she was out of custody,
Yeah.
and she just went to the turn, so we're
Okay.
on the Wayne County.
So we're good, it's just whatever we have.
You're copacetic.
Let's get her out this instant, but I understand.
Yeah. Okay, is there anything else? Well, let's go off the record until we get, are there civil cases to report here? Are there civil cases to report?
Yes, Your Honor, it's not not mentioned.
Oh.
We can recall Mitchell versus Mitchell.
Oh, boy.
We've had some success, but not all the way.
What keeps you in business? Everybody was in the court, got to do without a job.
That's what I always try to tell myself, yeah.
Okay,
Your Honor, the court asked us to try to determine what sort of backward intervention classes might be available. We've made a couple of calls. We've found one in Crossville, Tennessee that is 27 weeks. My client's position is this. He'll be happy to enter into that program and complete it if that's what the court directs.
yeah.
He's already.
How much does it cost?
It's $25 a session and it's so much per sign up. It's a reasonable cost. And Crossville's closer for him. He lives in Pickett. He's previous to that completed his domestic violence 4-hour course.
Okay, is there some place that we can do a kind of graduated visitation that they trust in being present with somebody else or city kind of works through this thing a little while and take a look?
We would
at it?
have great flexibility, Your Honor.
I'm asking for a name and a location. Is there a family member that's trusted of his?
She would want it to be, I think therapeutic. There's a pending.
You want what now?
She would want therapeutic.
There is severe violence and.
I understand. I'm not asking you. I'm asking you if there is a safe place with a family member of his or yours that would accept him be there for him to have some visitation.
My dad and my mom, he could do visitation with them.
Well, is that okay with you? See, that's a great suggestion. Now, do you take them to church on
I
Sundays?
do, yes. I do.
Okay, so Saturday would be a better day, right? Well, let's start out with, you contact your parents, make sure they do that. Okay, and let's start out with, Saturdays from like 12 to 3. Every other weekend to start it out, okay? And your parents live here in Clinton County? Okay, I want you, to come, I don't know whether you have any limitation,
I'm
yes.
sorry. My children have not seen this man in 7 years. Do you think that we could do this in a therapeutic environment though? Because they do not know.
Okay,
who he
I'm
is.
not, listen, your parents are gonna be there.
I know, but they don't know him.
I'm not gonna let you argue this case. I'm gonna tell you
sorry.
something. Step back,
Okay.
just step back. What I'm gonna tell you is we're gonna see if your children are willing to do that without you telling them that they need to have to do it in a therapeutic situation, okay? You need to ask your parents. They feel safe there with your parents. If he comes there and is scheduled and they're not willing to see him, then I will have your children interviewed by someone, okay? Now, but you cannot presume that they have the level of hostility toward him that you do. And I'm not saying your hostility is not justified, okay? I'm not saying that because you were a victim, okay? I just asked you if there was a place that would be acceptable for them to visit and you gave me your parents. So we're gonna try that, okay? Now, if he needs to come in soft, you need to come in soft. And you don't need to try to talk them in or explain to them where you've been or any of that sort of stuff, okay? You know, we'll just try it. So-
And Your Honor, there is the restraining order in Tennessee, so I'm not sure if that's something.
Dealt with that.
I don't know.
It's still active.
I think there is an active one, so I don't know we would need to address that.
That held this thing up for a year.
Well, I'm not okay, here's the deal. We have interstate agreements about accepting restraining orders in another state. I'm just trying to advance this thing.
I understand.
Okay, and let me tell you, I don't see how these children are endangered. You're not to have any weapons on you, you're not to have a pocket knife, you're not to have any weapon of any kind on or around you. You know, now, if your parents are not comfortable with this, you need to tell somebody they're not. And then we'll find someplace, but I thought it would be for your children's purpose, that someplace where they're comfortable and you don't have to take them to a therapeutic institutional situation to make them go there to people that they don't even know, the therapist or anybody else.
Well, and I mean, the concern was that this therapist said she couldn't even make a recommendation, so that's why we were hoping
Okay,
for.
here, do you really want, you know,
Well, and that's fine.
let
I'm
me
not
tell you
saying-
what, I can understand why this has made no progress because y'all keep moving the goal. Keep moving the goalpost on this thing. That's what you're doing. Nobody said anything about therapist or this or that when I asked if there was a place and you said there was a place and there were the parents. Now you're talking about the therapist being there and all this sort of stuff. And that might be what's necessary, but I was just trying to move it forward.
And
Go ahead, what do
I
you
have a
have? to say?
question, Your Honor. And
Would y'all move that stuff away from the microphone and get behind them
Yeah,
so I
her
can.
parents are very respected people. They're good people and there's no issue there. And by the way, do they live in Wayne County or Clinton? Pardon? Okay. What's their address?
59 Castle Road. 59 Castle Road. 59 Castle Road.
Castle?
Castle.
Okay, all right.
You know, again, I'm
And-
just not sure that she
and-
understood
and
the
I wasn't
question
done.
that was being
So,
asked of her.
My question, Your Honor, is who can be there? I don't know. if it's
Okay, here's the
perfect for her
thing
to be
about
there
it.
or-
It appears to me that they're not willing to do that.
Well, they say they are.
Well, are you willing to do that or not?
I don't think she is. I think there's two issues I would like to bring up. to
I'm
the
talking
council.
about this lady here, the mother's not willing to do it.
Are you agreeable to that?
I misunderstood.
Okay, so I don't think she's agreeable. Our two issues are the court order for them to go to this licensed clinical social worker. The licensed clinical social worker says she's not able to make the assessment that we wanted, the recommendations about time sharing custody. I would ask for them to go to a psychologist to do that. And for him also, this therapist also recommended for him to do something for his sobriety. So we would ask for that to occur. And if we're not inclined to send them to a psychologist, we would ask for the visits to occur in a therapist
Okay,
setting.
look. You're asking me to go into a mist. You keep on talking about this psychologist, that psychologist, all this sort of stuff. I've asked you to go out and call some people, and now you're talking about a completely different parameter of this thing.
No,
Now, I'm getting frustrated.
and I'm really not trying to frustrate. We're talking
No,
about
you're
different
trying to
things.
prevail, and I'm getting frustrated. Now, the thing about it is, I don't uphold anything that this man did right here. It's a terrible thing. But at some juncture, he's got a right to have some visitation.
And we're looking at different issues. We called for the batter's intervention program. I'm concerned though about these children. They haven't seen him since they were infants. His domestic violence, he hasn't had any domestic violence against her in 7 years, but he broke his other girlfriend's jaw 2 years ago. So I mean, it's an ongoing, there's a danger to those kids. I'm concerned about those children.
I move that be stricken. That's no.
Well,
That's incorrect.
I'm concerned for these children. I
Do you have any
wouldn't,
proof of that allegation?
we do have a protection order. I can-
No, about from the girlfriend.
I don't have the girlfriend present. We have the criminal. We have
Your
the-
Honor, we look at the case number on this. We've been trying to get something done since 2020 on this. And you see what we've been running into, and I don't uphold what he did, and he doesn't uphold what he did. But the court understands it's time to try to get this man something, and I know you're trying to, and we'll cooperate to whatever the court says.
And since I've been in the case, we've asked for the same things over and over. We either want there to be a custodial evaluation by Dr. Evans and Dr. Feinberg. She would divide that cost. And I
Where
know
are they
that
located?
they are in Lexington, so I know that's.
How much is it gonna be?
Those are, I mean, it could be roughly $2,500 to $5,000. That would be expensive. We do understand that. So we were trying to find different things. That's why we hope the licensed clinical social worker would make a recommendation. She
No,
says
they're
she's not going
Nobody's
to.
gonna make recommendations because they don't want the liability.
Yeah, so she did recommend the batter's intervention. We found where he could do that and something to maintain his sobriety. I mean, we thought outpatient therapy, but we still don't have anyone that's looked at how this is going to affect these children.
Okay, well, I tell you what I'm gonna do. I'm gonna order that intervention as far as the visitation. We can get that more quickly, and I'm not gonna order him to do any batters thing or any of the other things right now. Let's see what this report says. Okay,
I don't know if I'm following. You're not going to order him to do better.
I'm a little confused. What report are you?
the Lexington people that are gonna talk
Oh,
about
go do the
visitation,
custodial
we're gonna go up there and
evaluation.
let them do an evaluation. They can do that more quickly.
Okay.
Okay, as far as the impact on the children are concerned. he's gone through this anger management and stuff. That's gonna satisfy me with that stuff, okay? Now, if you've got anything that has happened since he did the anger management thing that thinks that didn't work, then you can bring it up.
So, I mean, I think he just did like a 4-hour class or something. I don't know.
I don't care. That's good for me, okay?
Okay.
You can't have all these I mean, we're interested in the children. Go up there and he'll have to go up and talk to the people up there. She'll have to talk to people up there. They'll talk to the children. We'll do an evaluation of what impact, a gradual integration of him visiting at her parents' house until we can do more than that. And let them help us do a visitation plan at some juncture. Either that or you need to file a motion to terminate his parental rights. Because if you're not gonna let him ever allow him to visit, or you're gonna keep on doing these things, and I'm not saying she doesn't feel justified in doing it.
They already did that once.
Well, and I think she wanted to give him some sort of a chance. That's why this batter's intervention program was a
Well,
long-term
no,
thing.
here's the thing about it is she's not gonna dictate what he goes through. You know, you go up there and see what the people think in Lexington about what impact it would have on the children and that sort of thing. And I guarantee you, if he ever does anything in Clinton County for her or the children or anybody, you know, he'll get buried here. You understand what I'm saying? It'll be a bad thing. Because I'm trying to work through it where it's a terrible thing what's happened, and it's just as terrible for children to think their parent doesn't think enough of them to try to fight to visit. That's a terrible thing too. And so, you know, if they get to the point where they don't want to see him, they don't want to ever see him again, then they'll need counseling themselves where they need to reestablish. And then you need to be careful on what you say to them also, because you could be scorching them a long time. This violence and this hate and everything needs to stop generationally with what's already happened and not be passed on to these two innocents. These two innocents, and that's what they are. They're innocent. And we need to try to do something. So if y'all get together and send me an order, schedule and note that firm up there,
We could do that. And how do we handle the cost on this, Your Honor?
50-50. Okay?
Okay.
Okay, thank y'all very much. Now, is there anything else that where I don't have to do the Solomon bid on?
Thank you.
Judge, I feel like Mr. Garman is back there speaking with his client. He's came in, Dr. Wilson.
Something about. Let's go over there. Okay. Is this Wilson versus Wilson? Okay. Now, what do we come, any conclusions here?
Judge, at this time, we've not been able to reach a temporary schedule. I believe Dr. Wilson here is wanting to keep kind of a 50-50 time sharing. Ms. Thrasher, the mother, is currently unagreeable to that. She says the children have not adjusted well. They have recently had to been enrolled in counseling within the past week. They've been.
Where is that?
At the school, at the middle school and elementary school over here.
Who does it? I mean, is it like Adonta or some organization, or is it school council?
It's a school counselor, is my understanding.
Well, I don't know about that. I don't have anything to say bad about school counselors, but I think this kind of goes beyond the scope of what.
Cumberland Family Medical, I'm sorry. They have been contacting her, the oldest has been contacting her from school stating he wants her to come pick him up because he is scared. He's wanting to kind of talk to
We're gonna
her.
have to get some, I can't allow you to testify, you know, or be prejudiced by that. I'm not doubting it, but he has a right to confront him. And the attorney's saying this doesn't give him the right to do that. How old are they again?
13, so.
Both little boys.
Yes.
Is there an EPO or an EBO or any, nothing like it? No EPOs. What is there in place, anything?
Judge, there's nothing in place at this time.
What we're talking about this time?
There's nothing in place at this time. She does have some testimony stating that she does have a fear of Mr. Wilson.
Well, you know, if it doesn't rise to the level where she's taking an EPO, and quite frankly, people should be very careful because of the implications and consequences of EPOs. Yeah, that could be killing the goose that lays the golden egg, if you understand what I'm saying. So, I would suggest some sort of a mutual restraining order or something that sets out parameters of behavior that are acceptable. You see what I'm saying? It would have an effect. We would still have some court protection. I don't know what kind of discussions have been held with these children, what they've seen, or what they've experienced, or why they're afraid. Quite frequently, they're afraid not because of what they've seen personally, but because of what one of the parties has told them. You know, and might be a perception of it. I don't know. But the quicker we can establish some normalcy in their lives, the less damage there's going to be. Y'all aren't, it appears to me that there's not going to be a reconciliation here. I'm just feeling that. I don't know why I feel that way, but I would think that there's not going to be reconciliation. Then everybody needs to resign to the fact that y'all decided to procreate with each other at some time. And maybe that wasn't a good decision, but you got two blessings from it anyway, even if it wasn't a good decision. And right now, instead of all these other factors that you're worried about, you need to resolve what you're gonna do long-term, what kind of mutual restraining orders you might enter into, and what kind of visitation you're gonna try to establish. Now, I'm sorry, but are you originally from Clinton County? You know, you're much too young for me to know you. I might have known your grandparents or something, but you know, and I know members of your family a couple of generations back, and I probably do yours too. But so I don't know if there's a place that you feel safe with him having visitation for a while or back and forth. And I don't know. I'd have to have testimony to establish that it even needs to happen.
Well, Judge, could I make a little suggestion in the interim here? Mr. Garman and I kind of discussed potentially a friend of the court, if the court feels that this is an appropriate situation to appoint one.
What would the friend of the court do?
I think perhaps be a neutral party to interview these children and kind of assess these fears and concerns in a neutral environment, perhaps.
You have any suggestion on who that might be?
We've kind of kicked around the idea. We don't really have a suggestion.
But we can talk.
Yes.
Well, some of these people have positions, just trying to think of something. What about Miss Capps? Is she gone yet? Did she leave? She said you catch Miss Capps. She's a, you know, a strong person. She has children. See if we can find her. And maybe we can get it done quick, too, you know, like she can interview people. How long has it been since you've seen each other? Do what? Where did you see them?
I've had them since November.
They've been continuing 50-50 visitations since
So we
November.
have a problem with that?
Judge, the mother's concern with that is the behaviors that the children have started displaying, the fact that they
Okay,
needed.
well, here's the thing about it. Then the counseling, if they are doing 50-50 now, if the counseling they're receiving is not sufficient, I don't know what kind of counseling they're receiving. Are you satisfied with the level of counseling they're getting?
They just started last week, so.
Yeah, does the person, what credential does the person hold that's doing the counseling?
It's Richard York.
I didn't need to know his name. I just know what credential they have. Yeah. Doctor, are you satisfied with the credential of the person that's doing the counseling? Okay. Okay, let's see if we can find her.
Judge, I think mom here is kind of wanting to establish a more consistent schedule with her being there multiple days instead of kind of a day with mom, day with dad. The back and forth seems to be getting to them, is mom's opinion.
You know, I don't really like this time sharing stuff either. You know, I think, but that's the law. You know, and you know, I have a tendency to think that some parents should be the primary custodial parent, other parents should have visitation, long periods during the summer stuff, but that's not what the law is. You have to make certain findings along those ways, you know, so that's what I'm gonna do. Unless you got testimony to the contrary, and I can take that testimony when we go toward permanency, knowing that it's a big hill to climb. So and you know, there will be other issues that develop as far as what do you do, ma'am, for a living?
I'm a nurse.
Okay, and a 4-year RN, 2-year RN, and where do you work?
Evolving.
Yeah. And are you a supervisor or a floor nurse?
An emergency.
Emergency room. Well, then we'll get it, you know, if they got 50-50, we'll get into where there's gonna be child support, then won't we?
Yes, Your Honor.
How long have y'all lived together?
18 years.
Longer than most marriages.
Well, I would suggest that you, we'll get a hold of Miss, did you catch her? Okay, well, let me see if I can get her on the phone. Siri, call Angie Cass. Are you out of town here yet? Yeah, well, I need you to come back up to the courtroom. There's a possibility of a friend of the court thing that needed to get pointed to if you come back, okay? Thank you. Mr. Garner, you see how promptly she answers the phone? You should let it be a lesson to me.
Judge, while we're waiting, do you want to take any sort of testimony, as to the mother's concerns with the father, or?
And Judge, he has concerns as well.
I don't know how in depth you want to get.
You know, I don't want it to be a person. I mean, either she got a level where she has enough fear that she needs to get an EPO with the consequences of that, or you do a mutual restraining order. Let me say that again, a mutual restraining order that will make your client feel comfortable, okay? If we can't do that, then she needs to file an EPO and let me make a determination on that, with the uncertainty that's involved as whether it rises to the level of getting protection. Okay?
Judge, we'll agree on the record to mutual.
Well, I know, but you know, obviously you would because you don't want to risk an EPO and the consequences that it might have. And, you know, I can't make, there's no reason for me to take testimony if we can't reach an agreement. If we can reach an agreement, then that's fine. If her fears rise to the level that would be necessary for EPO, she needs to file one and let me hear testimony on that and decide. Does that seem fair to you? Ms. Perigin? You know,
Yes, Judge, I've discussed the possibility of an APO with her.
okay. I don't know where she was, but she said she wasn't out of town. Well, let's go off the record. She gets here.